of Europe project, which is about supporting the judiciary in Ukraine to provide better access to justice. Today, I will moderate this roundtable, where we're going to discuss a very important date, 25 years of the implementation, ratification of the European Convention on Human Rights by Ukraine. Is this a lot of time? We will be discussing this today with the people who are implementing, who are forming policies, with the officials who implement policies, and representatives of the Council of Europe who are watching us in a friendly way, both the first and the second process. This is a live roundtable. We can be watched by the audience using both the English and Ukrainian channels on YouTube. Therefore, I'd like to give the floor to Andrei Kostin, head of the Parliamentary Committee on Legal Affairs of the Ukrainian Parliament, with support of which we are having this roundtable. Andrei. Thank you very much, Irina. Thank you for this initiative. I remember when we discussed it some 2 months ago, when the situation is very complicated today with account of the aggression of the Russian Federation against Ukraine. However, 2 months ago, when we discussed the idea that we have to mark this date, the 25 years of the ratification by Ukraine of the European Convention on Human Rights and Fundamental Freedoms. And we decided we should do it jointly with the understanding that it is the Ukrainian Parliament that back in 1997 ratified the convention, which now is a road map for many legislative initiatives, which is a roadmap for all the legislative, executive, and judicial authorities. And today I would like to remember many events that started at the time when the convention was ratified. I'd like to greet everyone whom I know personally, the ones we have talked to while I worked at the Parliament, and also those that we met at the time when I worked as a lawyer. I'd like to show you this book. The book is called the European Convention on Human Rights, the main provisions, the practice of an implementation, the European context. That's 2004. It was a joint project. It was published by a joint project of the Council of Europe, the Ukrainian Bar Association, and the International Center for Human Rights, Inter-Rights. And I, as a lawyer, participated back then in a very systemic training course that lasted more than a year and a half. Because definitely the European Convention at that time was a completely new document that required training not only for the judges but for the lawyers that people started turning to, and as well as legal persons who saw in the European Convention an effective tool to protect their rights and freedoms. Today with us, we have one of the trainers of that course, and that's Mr. McBride, professor of Birmingham University at that time, and a human rights expert of the Council of Europe and OSCE, who also worked with Inter-Rights project at that time. And it's very symbolic for me that today, on the day when with support of the Committee for Legal Affairs that I had, that we have this event today. Today we have with us those people who were, as they say, at the roots of making the European Convention on Human Rights popular in Ukraine. For me personally, this is a very important symbol because it means that the European Convention in Ukraine is today one of the instruments that is used by the parliament, by the judiciary, and that is very well known to many lawyers, judges, politicians, researchers, and the application of which is sometimes the last hope for many Ukrainians, physical persons as well as legal persons. I'd like to thank everyone who has agreed and decided to participate in this round table. I want to tell you that since the very first steps after it became independent, Ukraine said that it wanted to be a full-fledged member of the pan-European political, economic, humanitarian, and legal space. This movement is quite logical because Ukraine not only expressed its political will, but because of its geographic situation and historic development and the level of culture had always been part and parcel of Europe. And a very important key element for a successful implementation of its political will in terms of Euro integration by Ukraine is to reach a certain level of harmonization between the Ukrainian legislation and the Council of Europe law, primarily under the angle of bringing the Ukrainian system of human rights, both in its form and content, in line with the European standards. And the European Convention on Human Rights, by all means, plays the role of a systemic factor in this movement. During the years of its implementation, the Convention became a part of the national legislation of Ukraine. And as the Convention is a complicated mechanism, has a direct action within the jurisdiction of the Ukrainian courts, the principles of interpretation of the Convention used by the European Court of Human Rights have an important value. They are very special for the Ukrainian legislators as well as representatives of various government authorities, the system of Ukrainian justice. In the conditions of this war and mass violence, the level of violations of human rights is very high. Very many people are losing lives, health, their property. They're suffering huge ill treatment, and they require very serious protection and effective mechanisms that would respond to those violations. And first and foremost, it is very important to introduce effective legal mechanisms to protect human rights. The European Convention is not only one of such mechanisms, it has become the most important document for human rights protection for the people who have suffered during the war at the European Court of Human Rights. Besides, the conventional standards should be the main criterion to assess the actions of the aggressor country at the International Tribunal against the Russian military criminals. Today, the European Convention on Human Rights is the basis for further legislative and other standard-setting activities, and its provisions are a priority within the legal system of Ukraine. I want to wish us all today fruitful cooperation, good and interesting discussion. Thank you. Thank you very much, Mr. Kostin. I'd like to give the floor now to the President of the Supreme Court, Mr. Vsevolod Knyazev. Thank you, Irina. Good morning, dear colleagues. Good morning to all our guests. I'm very happy to welcome the participants of this round table where we're discussing the 25th anniversary of the implementation of the European Convention on Human Rights in Ukraine. This is really a remarkable event, and it's true that we have to speak about that. We have to have proper events so we all could understand and remember that the European Convention on Human Rights today is the basis for the work, well, in addition to the Constitution, of course, for the work of the judiciary as well as other government authorities in Ukraine. First of all, I'd like to thank our partners of the Supreme Court who have organized this important event, in particular to the Council of Europe project, supporting the judiciary of Ukraine to provide better access to justice and compliance with human rights within the criminal justice system, as well as the Parliamentary Committee on Legal Affairs and Mr. Kostin. I want to thank Mr. Giacomopoulos, Director General of Human Rights and Rule of Law of the Council of Europe, our reliable partner and friend, for his support and for his participation in this event. I would also like to thank Judge of the European Court of Human Rights, Nicola Henatovsky, who is going to speak today. I want to thank all the judges, all the government officials, all those who have joined this important event today. Without any doubt, the convention is the quintessence of the civilizational achievements. It is the roadmap, as Mr. Kostin correctly said, for implementation of human rights and freedoms according to the best standards, which we can see in the conventional provisions as well as those that come out of its interpretation. Only under those conditions a man in the 21st century would live in a country that meets its best interests. It would not become a victim to arbitrary violations of its rights and freedoms, either by the state, the government, or by other members. We've always thought it was an axiom, because since 1997, the convention has become for Ukraine a real roadmap. And all those 25 years, Ukraine has been taking the road of development and improvement so that those provisions on paper would become a real protection of human rights. It's hard to overestimate the influence of the convention on the development of Ukraine's legal system, and it grows with every year. We see that in the legislative work, which suggests that the national legislation be brought in line to the convention, as well as in the application of the law when certain conflicts would be resolved according to the approaches formed by the European Court of Human Rights. I want to emphasize that today, when any important legal issue is discussed by the Supreme Court, before that, we analyze the case law of the European Court attentively so that the decisions of the Supreme Court would be in line with the Convention and would meet its letter and spirit. The role of the Ukrainian judges in the implementation of the case law of the European Court can be seen in its individual measures, such as reviewing court decisions under extraordinary circumstances, because when the European Court finds a violation by Ukraine of the Convention, when the conflicts were heard by the courts of Ukraine, well, of course, the court can develop the legal opinions that would have this precedent meaning for our practice. I will not speak about individual cases because we will hear representatives of the Supreme Court speak about that. However, with all the importance of the individual measures, they are primarily about correcting the violations that took place vis-a-vis the applications or the applicants. But the government should make sure that the violations found by the European Court would not take place in the future. And this is what the general measures are about that should be applied by all the government authorities within their competences. In particular, if a violation has taken place because of imperfect law or the absence of a proper legal act, and this is what the Grand Chamber of the Supreme Court often faces as it hears cases after they have been heard and violations were found by the European Court of Human Rights. In that case, the Parliament, the Cabinet of Ministers, or other authorities should adopt proper legal acts to improve the situation or to establish a proper legal norm. At the same time, a very important role in the application of the general measures is played by the judiciary. And this role is based on its standard setting function that the courts also have. The courts should be proactive in this respect so that their practical work would be in line with the convention without waiting for the European Court to adopt decision against Ukraine. The conventional mechanisms are not stable. They keep developing. We see that new instruments are developed. Protocol number 16, for example, which helps improve the dialogue between the national courts and the European Court, as well as the network of high courts that allows us to find the relevant case law of the European Court, which in general helps prevent violations of the convention by the government. Besides, the case law of the European Court keeps developing. There are new legal and social relations. The states keep developing. The conventional mechanisms take care of those challenges. Signing the convention took place when Europe starting getting back to life after the horrors of the Second World War, and it had to protect, to guard human rights and democratic values of the society. Now, the biggest challenge of 2022 is this full-scale war in Europe conducted by Russia in our territory. All the violations of human rights and freedoms that could happen here have happened, and unfortunately continue happening every day. Every day we keep losing people, keep burying our people. We feel the negative challenges of our infrastructure being destroyed. I am certain that the enemy will be destroyed and that the leaders of the Russian Federation will be properly prosecuted, and the convention and other important mechanisms would play an important role when holding every criminal to account. Separately, I would like to say that the war has given the judiciary new tasks and new challenges. These are lost lives of our judges and staff, the facilities, equipment, the courthouses that have been destroyed, our judges who are in the occupied territories, underfunding of the judicial system, the problem of understaffing. We have a serious problem with improving the mechanisms for remote work of the judges. Many people have left their homes and have changed their residence, and some of them are abroad. So this problem requires a quick solution, including with account of the need to have proper timeline for hearing court cases. We see many problems we have to work on, the ones I've just named, as well as the ones like the failure to enforce the judgments such as Yuri Mykolaievich Ivanov and Burmich versus Ukraine, the problems with proper timeline for proceedings in the courts, Merit and Naumenko, Article 5 with the pre-trial detention problem. Let me remind you of Ignatov versus Ukraine and others. However, I'm sure that all those problems, Ukraine can overcome them. However, to do that, we need to have proper cooperation between various government authorities and our international partners. Once again, I will confirm that our court is ready to participate actively in this process. Thank you for your attention, and I wish you all fruitful work. Thank you very much. About the ratification of the international convention, it's probably the national parliament that learns about it first and foremost. But the ones who feel the ratification is the national court, of course. In every country, the judges are the first people who would feel that now there is a new element in the system. Today, we have also invited here a person who since the very first day, since 1997, has been following the implementation of the convention by Ukraine, who has taken every stage of the challenge of it, who knows how the national courts feel the ratification and every government authority. I'm giving the floor to Christos Giacomopoulou, Director General of Human Rights and Rule of Law at the Council of Europe.
Well, thank you so much, Irina, for this wonderful introduction. Dear President, President of the Parliamentary Committee on Legal Affairs of the Verkhovna Rada, Mr. Kostin, dear President of the Supreme Court of Ukraine, Mr. Knyazev, dear participants, this online roundtable is not only a wonderful opportunity to see many of you who are friends and colleagues with whom we have worked for many, many years and long years together, but also a welcomed opportunity to look together at the developments in the legal system of Ukraine since its the ratification of the European Convention of Human Rights in 1997. You have already referred to this important moment for the legal community and also for the citizens of Ukraine. Unfortunately and sadly, this event takes now place in the context of the war. And I would like to recall that following the aggression by the Russian Federation on the 24th of February, the Russian Federation was expelled, ceased to be a member of the Council of Europe. Our organization stands united with our member state, Ukraine, in the face of this aggression. And this support, this solidarity, takes also the shape of our priority adjustments to the Council of Europe Action Plan for Ukraine 2008-2022. These adjustments were defined together with Ukraine, with you, with the authorities, and they were agreed by our 46 member states at the ministerial session in Turin in May 2022. These adjustments cover many areas, including the provision of advice with regard to the implementation of the European Convention of Human Rights, whose 25th anniversary in Ukraine we celebrate today, the implementation of the European Convention on Human Rights in times of war, and the documentation of human rights violations, gross human rights violations happening in Ukraine, and measures to support the functioning of the judiciary during the wartime, but also support to the protection of displaced persons, support for the legal professionals, in particular in close cooperation with the judges, the Prosecutor General, the Prosecutor General's office, and also assistance to the Ukrainian media. This is only some of the examples. And we are looking also beyond that, these adjusted measures. Our Secretary General, Maria Pecinovic-Buric, said earlier this month at the Lugano conference, which dealt with the recovery in Ukraine, that Ukraine's recovery requires good governance and European values to underpin this recovery efforts. It needs democratic security as the basis of a lasting peace, so that stability, prosperity, and progress can take root. I think this is precisely what we try to do as an organization, as the Council of Europe, help Ukraine, not least for its European Union aspirations. No doubt that the latter, I mean the EU accession, the support to the reforms of Ukraine in this field will be very crucial, essential. This will probably constitute a very important part of our work with Ukraine in the times to come, along, of course, with the continued support to the functioning of the institutions in the present situation. Now, let me come to this, to today's anniversary of Ukraine's ratification to the convention. I must say that we shall all acknowledge that Ukraine has achieved many meaningful results in the implementation of the convention in the 25 years. The progress is visible in all areas: democracy, human rights, rule of law, reforms to the justice system, territorial and administrative reforms have taken place, electoral reforms have taken place. All this has taken place since the ratification of the ECHR in conformity with the European Convention of Human Rights. And it is firmly relying on the provisions of the European Convention of Human Rights and the interpretation of this convention by the European Court. One of the recent achievements should be highlighted, I believe, and this is the ratification by the Ukrainian Parliament of the Council of Europe Convention preventing and combating violence against women and domestic violence, the Istanbul Convention. As our Secretary General commented in this regard, this is a huge step forward in protecting women and girls from all forms of violence. And of course, further work remains to be done in this field, but we will remain on Ukraine's side to assist whenever needed. Among other areas of importance for Ukraine, I would stress the need for a full execution of judgments of the European Court of Human Rights. The President of the Supreme Court already referred to this, including, most importantly, the adoption of general measures, legislative reforms or administrative practice reforms, which are required to address the structural problems that have been identified in these judgments of the European Court of Human Rights. We should acknowledge that there are extremely difficult situations, circumstances now, but also that the problems that have been already identified, such as the non-execution national court judgments, the Burmich issue that President Knežević has referred to, and the length of courts proceedings should not be put aside. Concerning the functioning of the judiciary now, we should also note and underline the difficult role that the Supreme Court of Ukraine is undertaking to support the smooth functioning of the judiciary, especially in situations as the present one where the two key self-governing bodies of the judiciary, the functioning of the two self-governing judicial bodies is suspended. I mean, the High Council of Justice and the High Qualification Commission of Judges of Ukraine. And in this regard, I think that the efforts of the Supreme Court must be recognized, as well as the parliamentary efforts, the ongoing legislative work to ensure a safe judicial functioning, including the possibilities for online adjudication of cases. Dear friends, in the context of the military aggression, the very difficult circumstances of this war, it is important to continue to pay special attention to the effective functioning of the justice system. And this is also to serve the interests of the victims of war, to serve them properly and to strengthen the respect for human rights and international humanitarian law. Delivering justice for all victims of the war in Ukraine should be done in accordance with Article 6 of the European Convention of Human Rights and other provisions of the Convention, human rights in particular, the effective investigations, obligations that derive from positive obligations of investigation that derive from Articles 3, 4 and 5 of the Convention, and Article 2, of course. And this will require a strong and efficient court system, while the cases of this kind may become one of the major issues of justice in the foreseeable future in Ukraine. So, Mr. President of the Verkhovna Rada Committee on Legal Affairs, Mr. President of the Supreme Court, dear participants, I would like to conclude by stressing that the Council of Europe recognizes the deep and comprehensive reforms that have been undertaken in Ukraine following the ratification of the Convention in 1997. These reforms were absolutely necessary for the transition from a post-Soviet country to a democratic country and society and state. And as is the case for all our member states in the Council of Europe, our organization is determined to continue working with Ukraine to support those further reforms and measures that are required in Ukraine as in other member states, and to consolidate compliance with the European Convention of Human Rights, and most importantly, to support Ukraine in times of war and its European Union aspirations. Thank you so much.
Дякую. Дуже дякую за такі змістовні вітальні слова.
Thank you so much for in-depth introduction to the round table. Now, allow me to invite Nicola Henatovsky, who recently has been appointed as the ECHR judge representing Ukraine. And national-level judges sometimes behind the scenes may say that the public doesn't understand them and the politicians don't understand them, and no one reads their judgments, but the ECHR judges can probably say the same about all communities in the EU and the members of the Council of Europe, and everybody who wants to criticize the case law of the ECHR because they probably do not know the details of that. Allow me to offer you a very interesting report. It's called 25 Years of the European Convention on Human Rights in Ukraine and whether the changes are needed towards implementation. Maybe 25 years is that exact threshold when we have to think about altering, changing approaches to its implementation. Thank you. Dear President, dear judges of the Supreme Court, dear head of the legal committee policy, dear director Giacomopoulos, dear colleagues, dear friends, I am very happy to take part in this roundtable. And today the situation is quite interesting. You know, it's kind of a celebratory occasion, 25 years of ratification of the European Convention on Human Rights, and this is indeed a very special event for Ukraine and for Ukrainian legal experts and legal professionals. But today, Ukraine is on the front line, verbatim. We are fighting for the values which are embodied in the text of the Convention, the values which brought together 46 member states of the Council of Europe. And this war is not just for Ukraine's independence and its further existence. This war, and this is what I believe in, this war is for human rights in the European continent, for democracy and the rule of law in the European continent. All those things around which the European project was built after the Great War in Europe, the Second World War, ended. And nothing like that never happened in the European continent since then. I'm talking about a fully fledged war waged by one country against another, and that creates a context which is quite hard and incomprehensible for empty talks. We want to be very specific. We want to apply measures, everything we can, in today's very complicated stage of our development. For me, this is a very hard stage in my life. As Irina mentioned just now, next week it's going to be a month since I took the oath as a judge of the European Court of Human Rights. And things I'll be discussing today, they are based not as much on my experience working as a judge in the ECHR, but it's based mostly on certain things I brought with me to this court and certain ideas that I have formed in advance before doing this as a Ukrainian lawyer and after cooperation with the Council of Europe. 25 years ago, when Ukraine ratified the convention, in the legal system of Ukraine, there's been some serious tectonic shifts. Ukraine bade farewell to its totalitarian past. Ukraine ratified the European Convention on Human Rights, and that was a way to make the European choice. The membership and the ratification, that means choosing the supremacy of law, the rule of law, and the democracy. Those are fundamental things for any further development of the state and integration in economic and political sense with the EU, which is also an objective of the state of Ukraine, and we've been having it for a while. And some time ago, it was solidified in the text of the Constitution of Ukraine. Now, between the Constitution of Ukraine and the European Convention on Human Rights, there are some very important DNA-level ties. And prior to ratification of the European Convention on Human Rights, when the Constitution of Ukraine was drafted back in 1996, and when Section 2 was adopted, and it was not done by chance, it dedicated to the fundamental freedoms and rights, and that mirrors everything that the European Convention on Human Rights is saying. The European Convention, which is a living tool, which is developing and evolving because of its constant interpretation and application by the European Court of Human Rights, and that has become a foundation for the constitutional order of Ukraine and the foundation for the legal processes and in Ukraine. And all these concepts and views and ideas that exist in all of the member states, which have been solidified in the judgments of the ECHR, naturally have become a part of Ukrainian legal system, and they have to be taken into consideration at every stage by the legislature, also by executive branch, and unconditionally they have to be taken into consideration by Ukrainian judges. In this sense, in this understanding, the dialogue between the ECHR and Ukrainian state, and first and foremost its judiciary, that is not just a consequence of international commitments of Ukraine or something that is desirable from the standpoint of improvement of implementation of Ukraine's commitments. That is a natural thing for Ukraine that has been embedded into the constitutional system of Ukraine, into the constitutional setup. And it's not just the constitution of Ukraine that has these ties with the convention. The Ukraine's accession to the Council of Europe was accompanied by not just commitments to adopt the constitution, because back in 1995, there's been an opinion made by the Parliamentary Assembly of the Council of Europe on this topic, but also there are veterans of the process, and you probably remember the opinion of the Parliamentary Assembly from back then. They were talking about the codes and key legal acts, which will determine the backbone of the legal system in Ukraine. And these codes were properly adopted, and they helped change a lot of things in a positive way in Ukraine. And today, I'm very happy to see Jeremy McBride, who Mr. Costin referred to just now. And also, I should recall the process of adopting the Criminal Procedure Code from 2012. And Jeremy took a very active part as an expert in that process. And also, it's very important to mention that this code has changed the situation in Ukraine, although its application is not the best sometimes, but by and large, it's been a huge step forward. In Ukraine, because of the ratification of convention, because of our membership in the Council of Europe, the civil society has grown and became stronger.
We now have multiple civil society organizations and lawyers, legal professionals who specialize in advocacy in the human rights area, and they have in-depth knowledge of the relevant legislation. So they have become that critical mass. They have become that watchdog that doesn't allow the government to fall behind. So those are the people who, first and foremost, will be able to ring that bell, to ring that alarm if the problem arises. We do have watchdogs, as you call them in English, and that is a good thing. And this is quite important. And in other parts of Europe, things are not as good in this regard. I'm talking about mostly the reputation of the European Court of Human Rights, and that can be explained by that negative attitude which the public has adopted to the national judicial system, in Ukraine specifically, because of different reasons. But there's been a lot of hope to the European Court of Human Rights, and it's still that high in Ukraine, and that also means lots of responsibility for the court, for the lawyers, legal professionals of the court, because you don't want to frustrate the feelings of people who have those great hopes. So the understanding of importance of convention for Ukrainian legal system has been reflected in a number of very important legal acts of Ukraine. And we must mention the law that dates back to 2006 on execution of judgments and case law of the European Court of Human Rights. So that law is key in today's presentation that I am making. That laid the foundation to understanding of the case law of the ECHR, and that law laid the important foundation in terms of the judgments of the ECHR should apply in Ukraine and viewed by the judges as the source of law. The idea behind this must be welcomed. And it's been so much time since then, and now we can have a look at the results of this process, the results of this approach, and I will get back to this idea a little bit later. Nevertheless, in spite of all the good things, which we have plenty, if we pay attention to the statistics of the ECHR judgments, where they found violations of convention by Ukraine, you can see that in spite of this constant desire of being an A student in this class, from the standpoint of actual marks in your gradebook, traditionally we were the worst students. Somehow, that's the paradox. One of the worst students, who is, by the way, ready to die for European values and for the school where we are all in, for the European Convention, in other words. So, and that has manifested itself not just because of the armed aggression of Russian Federation. We saw this back in 2004, 2005, when the public responded to the attempts to falsify the results of elections, and also during the Revolution of Dignity back in 2013 and 2014. So those are the elements that are a part of one timeline. And now, when Ukraine faces losses, not just material losses, but also we lose our people, our citizens, every day. And we see the tragic news every day. And we see that for Ukraine, we now have a chance to strengthen our country and to rid ourselves of the legacy from the totalitarian past and to build a more effective state, a state which will be able to integrate into the EU without some serious difficulties. And there are two important aspects to this: how the European Court of Human Rights can help and what Ukraine can do in this regard. Now, speaking about the organization, Christos, by the way, mentioned these ideas in his introductory remarks. Those lines of work of the Council of Europe, which we know of, and which Ukraine actively was promoting with the help of the Council of Europe, they remain relevant even today. They are very important for good understanding and implementation of the Convention. Now, we are talking about development of standards, which are based on the Convention and other important conventions, such as the Istanbul Convention, which also has been mentioned today, and many more. Also, we must mention the monitoring agencies of the Council of Europe, and we have to have a good dialogue with them so that the convention is applied, or the conventions are applied in the countries, and also participation in cooperation programs offered by the Council of Europe, very often together with the EU. So speaking about the ECHR and its work and how they should engage in the future, they should focus on the system-related problems and issues which our country has. We should continue developing solutions to some legal situations, and also we should work on some general measures which the state should use to address those system-related issues. And in that regard, I totally support everything that Christos mentioned with regard to the importance of execution of ECHR judgments, because that is a #1 priority. That is the most important thing we should work on right now, specifically in the aspect of system-related issues and general measures. Also, there is another important priority. We have to strengthen the national judiciary. In Ukraine, after the latest judicial reform, we have many grounds to hope that the situation got better. And Mr. Knyazov, the president of the Supreme Court, spoke about the role of his court, and those things are very important and positive. On top of that, I must say that it would be much better if we could have a fully functioning constitutional court in Ukraine. Specifically, the constitutional complaint mechanism should really be used in full. Unfortunately, this is not happening, and that would take the load off of the ECHR to a certain extent, and also that could bring the justice closer to the people of Ukraine and all the stakeholders, to all the actors in this sense. And of course, participation in the Superior Courts network, which exists at the ECHR, is very important. And also, it's very important to use the potential which is embedded into this idea. Now, speaking about the approaches to interpretation of the Convention, allow me to recall the law of 2006 and the concept saying that the judgments of the ECHR are used in Ukraine as a source of law. If we do not change this norm, we have to make it very specific in practical terms. So there has to be consensus among the judiciary. The key role is given to the Supreme Court, but then among the legal professionals in general, we have to have an understanding how to apply the case law of the ECHR. So the rule that says that we can find any kind of decision, any kind of judgment that dates back to a certain year, and then discern something from that and use it as a legal norm or the norm of the law in our judgments. Well, this idea, nicely speaking, should be discussed critically from the standpoint of the quality of those decisions, of those judgments and parts of those judgments. See, this is a living tool and it changes along with the case law. So the legal stance of the ECHR, it's not set in stones. It's evolving, it's moving forward, and those stances, those positions, they also change at the level of the ECHR. So when Ukrainian courts are applying convention in the way the ECHR does, they have to understand the latest developments from the ECHR, what they are talking about all this, based on some up-to-date cases. And, you know, the well-established case law, the established case law, not something else. And very often in the discussions between the legal professionals, they try to refer to specific quotes, you know, specific paragraphs where the stance of the state is quoted, and they want to use it to solve a specific case. There are so many conflicts like this. And in fact, they try to pressure judges to quote the judgments of the ECHR, to make their judgments better or to make some points out of this, which rating points, I mean. And that produces poor results and it's not helpful. So this superior courts network and its role, it's very important for Ukraine. And I hope that the Council of Europe will be able to provide some guidance, methodology to Ukrainian judges on this matter. But again, this is, you know, the structures where we work, which we represent, we all have to play our very important role. And the last thing that I want to mention, with your permission, is about the justice for the victims of war. This is what I want to mention. Justice, bringing justice for the victims, would depend on the general condition of the judiciary in Ukraine. Ukrainian courts, as the president already mentioned in the beginning, they come across some very, very difficult issues with regard to funding, and that is a problem of their physical existence, and security problem, organizational problem, and many more. So we have to give them support, and the judiciary has to function. Nothing will happen without functional judiciary. So we have to understand that the Convention on Human Rights and its rules continue to be enforced even today during the war, and we will have a separate presentation on this topic. As far as I understand, Professor Mark will be presenting on this topic. So there are some serious legal issues which need to be analyzed and discussed. And if we can make sure that our system is functional, the judiciary is functional, Ukraine, then we can attain our objectives from the standpoint of individual justice for everyone and from the standpoint of compensation mechanisms and supporting procedural rights and the rights of participants of the process. Also, in cases about grave war crimes, the convention still applies, and we still have to follow the rules of the convention, which it presents towards the right to fair trial and many other rights connected to that. So 25 years passed, and it's a long time, but for many present here, it seems like yesterday. And we do have a lot of work to do together, and I am convinced that relying on the Council of Europe, relying on the ECHR is a good thing for Ukraine. We can always do this. You are reliable friends of Ukraine, and your objective is to give support to Ukraine and its aspiration to become a modern-day democracy in Europe, which is based on European values and human rights. Glory to Ukraine, and thank you for your attention. Glory to the heroes.
Дякую вам за такий історичний екскурс, за порушення питання.
Very much for reminding us about history and about today. I think that Ukraine is a unique country in terms of implementation of the convention. I don't think there is another country like that, because most member states have implemented the convention and they studied the values of the convention and the European Court year by year, decade by decade. Ukraine did not have such a long period of time. It ratified the convention in 1997, and since that time, the same requirements were put for Ukraine, to Ukraine, as to the other member states of the Council of Europe that had had more time for implementation. That's not just a change of the legal system, that's the change of the values and the attitude to democratic values. However, to get back to our present time, as Mr. Henatovsky said, Ukraine should get rid of the remnants of the totalitarian system. And I believe that this process started on the 24th, or rather, it did not start, but the end of this process started on the 24th of February, the process of getting rid of the remnants of the totalitarian system. A new stage started that the aggressor thought to be the stage of destruction of Ukraine. However, without exaggeration, Ukraine is becoming stronger because of that. That's evident. How will Ukraine become stronger? How will it overcome all the challenges of the armed aggression started against Ukraine? And what the role of the parliament in this will be? To cover this issue, I'm giving the floor to Andriy Kostin, head of the Parliamentary Committee on Legal Affairs. Thank you, Irina. You know, after the presentations made by the participants, esteemed participants of this round table, the President of the Supreme Court, Mr. Knyazov, our permanent partner, let me put it like that, perhaps I have the right to say so, Mr. Giacomopoulos, and I would say a very motivating speech by the new judge of the European Court of Human Rights on behalf of Ukraine, Mr. Henatovsky. Incidentally, I have not yet had a chance to congratulate Mr. Henatovsky. I'm very happy for you and for my country. And I very much hope that your, I would say, your courageous work, your fruitful work as a judge of the European Court will really help this country, as Irina correctly said, to finally and forever get rid of the Soviet past. You said that too, but Irina formulated it as the day, the 24th of February, as the day when that final line was cut up, the line that had linked our country to the Soviet past. At least we all hope for it. After those speeches, I put aside my speech that I wanted to deliver today. You know, in this situation, I remembered again the 24th of February, or shall I say the 25th of February. On the 25th, the first meeting took place, online meeting. I still have this chat on my phone. On the 26th, a chat group was set up between the representatives of the Judiciary, the leading committees, the Prosecutor General's office. So, and Mr. Knyazov also would remember those events, and Mr. Alexei Salnikov, who is the head of the State Judicial Administration. He would also remember those days when we started our consultations, very powerful consultations on what we need, what steps should be taken first and foremost so that the law enforcement and the judicial systems would work properly during the martial law and the large-scale war. At the very first plenary meeting of the Parliament of Ukraine that took place after the beginning of the armed aggression, I'm not talking about the meeting on the 24th of February when martial law was announced, but the first meeting took place on the 1st or 2nd of March when the law was adopted that allowed us in the period of martial law to effectively, as much as it could be done within the constitutional space, to allow the judicial system to work effectively. Some of the authorities and competences of the High Council of Justice, unfortunately, because 10 members had resigned a day before the start of the armed aggression, the large-scale armed aggression, the High Council of Justice found itself in a state of limbo. And that's a constitutional body that plays a key role in the proper functioning of the judicial system. History will evaluate the actions of those members of the High Council of Justice who a day before resigned, maybe because they were scared. Well, I mean, maybe because I am not aware of it, but as a politician, I can't say that even in that sense. Perhaps because they were afraid of being checked for integrity by the ethical council that was set up thanks to the laws that the Ukrainian parliament had adopted, the laws that we all call the judicial reform of President Zelensky, that were intended to bring back the trust to the High Council of Justice by checking the integrity of the sitting members as well as the candidates and restoring the work of the High Council of Justice. So since the very first days of the war, we faced those challenges, but we saw complete consolidation and good coordination of our work between the judiciary, the Ukrainian parliament, and the presidential office. They allowed us to very quickly adopt the laws that allowed the judicial system to continue functioning. It allowed us to very quickly dispatch judges from the courts that were in the area of hostilities or who found themselves under a temporary occupation, to second them to other courts that allowed us to bring back the normal work of the judicial administration. There was not a single day that the state judicial administration, which is at the very epicenter of the developments, that's the government area of Kyiv, where in the very first days shots could be heard in the daytime and nighttime, as well as explosions, where we saw groups of saboteurs, but the state judicial administration kept working every day, just like the Ukrainian parliament and the Supreme Court. However, as I remember what Mr. Knyazev said, dear colleagues, I'd like to give you some figures that we have today that unfortunately these figures are the facts and the circumstances that really make the work of the judicial system much more complicated. As the situation is today, 15% of the courts are not administering justice. That's about 100 courts. And the territory that is not under Ukrainian control, we have 11%. That's 71 court institutions. Besides, thanks to the law that we adopted in early March that allowed the President of the Supreme Court to quickly change the territorial jurisdiction so that the rights and interests of the people and physical and legal persons would be protected even during the martial law. So the jurisdiction was changed for 132 courts. So those cases that were to be heard by the other courts that were now in the area of hostilities or that had been destroyed or that were in the temporarily occupied territories, the jurisdiction was changed, which allowed us to hear primarily criminal proceedings, because we told the judges that first and foremost they should hear criminal cases related to all kinds of saboteurs and special forces, potential suspects who had committed military war crimes or who were suspected of collaboration with the enemy, which is very important so that the society would be protected against such things and the society would feel justice toward those persons who are enemies or potential traitors. I would also like to note that today 9% of all the courthouses have been either destroyed or gravely damaged. I remember a picture that I received from Mr. Salnikov, the head of the state judicial administration, in the very first days of the war, when 2 buildings of the courts in Kiev were damaged as a result of missile hits. So their rooms were destroyed there. Luckily, in that situation, there were no casualties, but we know that unfortunately within the judicial system, there are people working in the courts, the staff who were killed or wounded as a result of shelling and missile hits. However, we continue working in full coordination, everyday coordination. We have been able to bring back the work of many judicial institutions in the territory that had been liberated from the occupiers. And these are the courts of Chernihiv Oblast, the courts in Kiev Oblast. Meanwhile, the situation, of course, is very complicated, but it is very important that in this period of time, we have this constant and permanent coordination between all the bodies of the legislative, judicial, and executive power. That's a very important message, and that's why I wanted to stress it, to assure you that any decision that we make, whether it is aimed at overcoming some strategic problems or aimed at some momentary resolving at the problems that we face every day, all these decisions are always made in close cooperation. I would also like to note, and you have 1 minute for it, I'd like to thank Mr. Giacomopoulos for his position in terms of further work on the execution, enforcement of the judgments of the European Court. Dear colleagues, 2 days ago, the Ukrainian Parliament adopted 2 laws to implement the Nemerzhitsky versus Ukraine judgment. That's our small but important contribution towards execution of the judgments of the European Court, even during the armed aggression and martial law. We will continue this work. And I would just like to suggest now we have the head of our subcommittee on the execution of judgments of the European Court, Mr. Babi, is present here with us today. And I would suggest that the Council of Europe project join us in having a roundtable with support of the subcommittee to set the priorities among those judgments of the European Court that we can now, in terms of the general measures that even now during the war we still can execute and implement in the form of the laws that we can adopt. I would also like to note that to answer a very important request of Mr. Henatovsky in terms of finalizing the law on the execution of judgments and application of the case law of the European Court. This work is now carried out by the subcommittee. It was very active before the armed aggression started, but I very much hope that we will get back to this work, and I would be very grateful to the project and to you for your support so that we can make this law more effective, so it would not lead to such situations that you have mentioned. And just allow me to have 2 more minutes. That's very important. During the armed aggression, Ukraine has taken a very quick road of the country that has become a candidate for the European Union. Now the committee and the parliament are working with a lot of energy to implement the recommendations we received from the European Commission. But we understand that these are not the recommendations of the European Commission for the European Commission. That's for the European society. And I'd like to note that the very first competition that was announced by the Parliament of Ukraine for the position to a new High Council of Integrity, High Council of Justice with integrity. It has passed the first hearing in the Parliament, and we expect to hear the first 2 new candidates who will report to the Parliament. We now have the Honorary President of the Venice Commission, Ms. Sukhotska. We want to thank you for our cooperation during many of our discussions in terms of the provisions of that law, especially as regards this new provision, the principle of integrity that has been established in the law in terms of its criteria that have been established in the law. That's our novelty, that's our joint common achievement, and which is very important to implement yet another recommendation. And Mr. Henatovsky has mentioned that as well, the role of the Constitutional Court. We are getting ready to introduce draft law on the new rules to select the judges of the Constitutional Court of Ukraine. And of course, we will cooperate with the Venice Commission so that those rules of selection would comply with the expectations of the Ukrainian society and our international partners. That's why I think that the model that we have proposed is going to be the one that would be completely in line with those requirements. And 1 more minute, Irina. One of the models that is being discussed right now is to create the same kind of an ethics commission or competition commission that would consist of 3 international experts who, well, this is one of the proposals, who would be recommended by the Venice Commission, and 3 national representatives who would check the future, the would-be candidate judges of the Constitutional Court for their integrity. And for the Constitutional Court to work more effectively, even now, we understand that setting up such a commission can take some time. So we have a proposal, an interesting one, that before this new commission is established on a temporary basis, the Ethics Council would perform the same function, the one that is now checking the integrity of the would-be candidates to the High Council of Justice. It's an element of trust, the confidence to the judicial reform that the parliament, the Ukrainian parliament, adopted last year. It's an element of trust to the work of that Ethics Council that is now checking the would-be candidates to the High Council of Justice. Thank you, dear colleagues. And I believe that our fruitful cooperation should be permanent. We all have but one objective, I'm sure of that, and our committee in the Ukrainian parliament are always ready to actively cooperate to approximate Ukraine to the best international standards of the Council of Europe. Thank you.
Дякую. Ну, слова сказані.
Thank you so much. You said it. Now we will arrange a roundtable to discuss the CHR judgment and the execution, and I think everybody supports this idea. So we will support this kind of initiatives of the Ukrainian parliament. Now, speaking about the role of the legislature in implementation of the convention, that will be discussed by Dmytro Tretyakov. And he is a legal professional. He is a secretary of the CHR, and he is looking into each and every case against Ukraine. He knows very well about the dynamics, how those cases changed, and he knows very well which branch of Ukrainian state are helping to reduce or to increase the number of cases at the court level. Dmytro, over to you. Can you hear me? Yes, we can. Thank you so much. Good afternoon. It was very interesting to listen to the previous presentations. My presentation will probably not be as interesting, but I will try to engage the audience. I'll be talking about the role of the legislature, of the parliament, in terms of compliance with the rights guaranteed by the convention. So when we talk about the case law of the CHR, we mostly talk about the negative case law, where there were violations. We have very few cases without any violations because mostly they don't end up in the chamber. They usually are discussed by the judges in question, and they address those cases themselves. And unfortunately, those positive examples are outside our radar. But again, we look at the case law in terms of Ukraine, and we can track some positive changes, which I want to discuss today. Now, speaking about the role of the parliament in protecting human rights, I can tell you that these rights cannot be properly guaranteed unless the legislature creates a proper mechanism for preventing violations, and unless they prescribe certain compensations for violations. Most of those rights in convention, they are not absolute, and means that they can be restricted, but on the other hand, they can be restricted only under certain conditions, including to guarantee the rights of individuals. Then there is very important set of rights. That's the right for information, Article 10, and the right to privacy. Because one of these rights cannot be absolute, because then you will negate the other right. But there's constant restrictions of these rights. They demand legality of such decisions. If you look at the text of the convention, they talk about legality, lawfulness in most of the articles. Article 5, the procedures introduced by the law, then Article 6, then Article 7, Article 8, interventions must be in compliance with the law, then Article 11 and 12, restrictions imposed by law, and then Protocol 1, Article 1, upon conditions provided by the law. Then Article 5 is also talking about lawful detention and so on. Now, speaking about restrictions and the lawfulness of that, that is a part 1 of the three-party test under Article 8, 9, 11, under which the court examines whether this intervention was in line with the convention. Then the court has to check whether this intervention was based on law, and when they identify that it was legal, then the court proceeds and tests whether this intervention was lawful and in pursuance of the legal objective, and whether it was necessary for a democratic society. Then the court makes two important requirements: accessibility and clarity. With accessibility, we don't have any problem with that. All the laws are public, they are open, and I personally use this very nice database, which is free of charge, of the Ukrainian parliament. And I never complained about that. So in the very beginning, there were a few cases that dealt with certain individuals, and the instruction, like official instruction, but it's a long story and I don't want to mention it. Now, speaking about this important norm, which is about clarity and foreseeable nature of a certain rule, and that allows people to regulate their acts, their behavior under certain consulting process. Then the court is supposed to look at the quality of the legal provisions which apply in a certain case. For instance, in the case Volov versus Ukraine, and it's an old case, there was this problem saying that the law envisaged the arrest of certain people and how to remove that arrest order. And then there was this problem whereby the claimants were under arrest, and then sometimes later there was this criminal case under which this arrest was imposed. That case was closed, and obviously the quality of law was not appropriate, and that meant that there was a violation. Then this foreseeable nature of legislation means that other branches of government should be able to interpret these norms in line with individual interests. So in Ukraine, there are different norms, different legal acts, and they were talking about different interpretation of the taxpayers' legislation, and then without any justification, court made a judgment just because of improper quality of the national legislation. They said that the rights of the claimant under Article 1, Protocol 1 were violated. Then Harnaga versus Ukraine case. The question was about the quality of law, which allowed to change the name, the last name also, and there was nothing about patronymic, or the situation was not clear, and that was falling under Article 8. The court found this a violation. Speaking about the quality of legislation, and allow me to show you an interesting example about the law being too good. So Holovine versus Ukraine, another case, and that case was about searches of the lawyer. And there was a rule, Article 10, the law on bar, and they talk about the general ban on seizing documents or disclosing documents which were handed over to lawyers or connected to lawyers' professional operations. The European Court said that it's still unclear how this provision relates to the legal operations of other participants of public life. So this article or other provisions of the national legislation don't produce specific exceptions, but the convention allows for those exceptions. And the court mentioned that that allowed absolute freedom for the national agencies to interpret and to apply this rule. And that means that it did not protect anything, and that means that it was not in line with foreseeable nature of the convention. The law also may contain a problem. As you remember, there was this procedure of revising the oversight procedure, and that procedure was repealed during the small judicial reform. And that demonstrates a positive example of legal work which can remove a violation which was embedded in the legislation with regard to the supervision. And speaking about other issues, lack of legislation, when intervention was not foreseeable by law, and Vorontsov versus Ukraine case. And you probably know very well about this case. So the court decided that that intervention was not lawful. And it was interesting because in the same case, the court looked at another kind of intervention because the claimant was held liable administratively under Article 175.1 of the Code of Ukraine on admin violations because allegedly that claimant violated the rules of demonstration. So by the code, there was a violation and the procedure of demonstration was not properly prescribed in the legislation at the national level. So because of the lack of the procedure that explains how demonstrations should occur, it's unclear how individuals can violate something that does not exist. So the court said that there was a violation of Article 7. And there were other problems. If you remember, there was a whole set of cases with regard to extradition and deprivation of liberty because of extradition. And in the Criminal Procedure Code, there was nothing mentioned about this special procedure. So they were talking about taking someone in custody as an interim measure before detention. So they found the violation, they changed the code, the old code. And in the case of law versus Ukraine, the person spent some time in incarceration before the introduction of the law and then sometime after. So they found a violation of the period 1 and there was no violation of the period 2. So Harchenko case, the court analyzed the progress of the state with regard to covering the legislative gaps connected to the previous detention in the criminal process. And yet again, this is the old Criminal Procedure Code. And I will quote now, in the case under consideration, the court found a violation of Article 5 of the Convention, which can be defined as the same exact violation that can be traced through all the courts of Ukraine. So detention, custody, without the authorization of the prosecutor. In this case, it creates additional problems which persist. So court constantly is mentioning violation of Article 5. So the court asked the state to introduce changes into the legislation. The court helped to introduce new criminal procedure code, and we thought that this will solve the problem, but still we had to work a little bit and refine the new criminal procedure code, because in China versus Ukraine case, the court said that in the Harchenko case, they found that there was this legal gap. Nevertheless, this problem still persists, and the national legislation requires further improvement. Also, apart from all that, even the law is violated, then, of course, this is the violation of convention. And today, it's been mentioned about the Dimorzhitsky case, and we had one person who spent some time in custody, and his custody was overdue, long overdue. Same that applies to Halp versus Ukraine case, when the claimant was brought to court for deciding on further detention after the 72-hour term lapsed, as provided by the criminal code. And then the government referred to a judgment of the ECHR versus Turkey, and they said that there was 4 days after detention, and the court agreed with that. So the European Court did agree. They said you can allow 3 or 4 days of detention, but the problem is that your national legislation instead introduces 3 days detention. And if you violate national legislation, you, by doing so, violate the rules of the convention, because any kind of deprivation of liberty has to be lawful and legal. Also, the legislation should apply with good faith to eliminate any arbitrariness. So there was this case, Novak versus Ukraine, and they were talking about an individual who was sent away to Poland, and the government knew that that person was wanted in Poland, and that was a concealed extradition. Everything looked okay and by the book, but that was a problem. when sometimes legislation is not applied in good faith. Then there were the other cases about application of law not in good faith, and Article 5. We have many cases when this and a situation when law enforcement would detain an individual for allegedly committing an admin violation. And then during this 72-hour of admin arrest, they would treat this person as a suspect in a criminal case. And we said that by law, everything looks right, but it means arbitrariness and violation in reality. Now, there is another issue which I want to mention. This is the issue under Article 1, Protocol 1, where the word lawfulness is used in two different cases. Number one, the Article 1 itself of the Protocol 1 guarantees the right to own property. And it says that no one can be deprived of property except for conditions provided by the law. And the state shall have the right to restrict, I apologize, not restrict, but introduce laws which the government finds important to control over someone's property. But as you have seen in shocking case, the equality of law is very important. Again, any kind of intervention must be properly justified by law. If there is no law that restricts the right to own, then there is a violation. Then there is another important sense of this Article 1, Protocol 1, when we talk about availability of law, lack thereof, which would allow to demand compensation, right? So in this case, the lack of any legislation does not create some expectations, legal expectations under this provision. The availability of provisions in the law would allow to have expectations for this individual for some compensation, some payments, or anything else promised by the law. And here we are talking about, first and foremost, the promises. And these promises, they have to have some material nature. So if the government is promising something, then they should do this in such a way where there is no discrimination against a group of people which are not supposed to be discriminated against. So there was this case Vishnu versus Ukraine. They were talking about an individual who left to Germany and stayed there as a resident, and that person was deprived of his pension. So the decision said that depriving someone of pension under this kind of conditions means violation of Article 14 and Article 1, Protocol 1. When the state is promising something, the state is supposed to introduce this without any discrimination. Now, speaking about the legal expectations, so there was this group of cases, inadmissible cases, and they are not translated, and they are not well known, but in the judgments of courts, they are still used. I saw some judgments of the national courts where they referred to them. So Zolotyuk, Petleva Portyanka case, where they talked about reimbursement of damage under the Civil Code articles 1177, 1173, and as it's been mentioned before by Ukrainian court, having lack of any further regulation and procedures for paying out this compensation, this claimant cannot have any legal expectations for receiving any compensation. At the same time, this practice has a downside when the states were trying to prove in one of the cases that the applications under this Civil Code articles is an effective remedy. We disagreed. The ECHR disagreed exactly because we said that those rules are not properly regulated by law, and that means they cannot act as an effective remedy. So speaking about compensations, which are now being discussed very often at the national level, the compensation for lost or damaged property, under Article 1, Protocol 1, the state must reimburse the cost of the property, the value of the property, which the government used for public needs in line with the law. If the state interfered with the right to own property, this individual may request compensation of damages. And it's not just during conflict, it's also in times of peace. Chigarov and others versus Armenia case, and versus Turkey, where they were talking about an explosion at a landfill that was nearby, and they found a violation, and the court stated that the state must compensate the damaged property to these affected individuals. The state, of course, has the right to implement certain social measures, and they may promise compensation for damaged property, even things where they're not responsible. In this Polish case, the government of Poland promised to the Poles who were relocated from the territory of Ukraine to get some compensation, and that was a problem because they somehow did it in a discriminatory fashion. And they talked about the right to own because the government made these promises. Then there was this Paskovsky versus Ukraine case, and the government of Ukraine did not promise anything to anyone. And in this case, this right to own did not arise because it's very hard, to be honest, to look into these cases when the government is promising something. They are promising these things in the shape of voluntary payments as a support to the citizens. And we have to make sure that this compensation is paid for certain acts of government. If there is the government's guilt in this violation. Thank you for your attention. I spent 20 minutes already, and if you don't have any more questions, let's proceed. Thank you.
Приєднуйтесь до наших заходів і завжди говорите по суті.
Thank you, Dmitro, for joining our events and for always talking about what we are discussing. But we have to keep moving. And I'd like to give the floor now to the Honorary President of the European Commission for Democracy through Law. And while you're turning your microphone on, let me tell our audience a secret to the audience who's watching us on YouTube. The secret is that not all the judgments of the European Court are decisive in the process of the implementation of the Convention into the legal framework of Ukraine. In some aspects, what is even more decisive, perhaps, for our development, for a common vision of how the legal system should develop as regards the buildup of the institutions, and for a certain period of time, the opinions of the Venice Commission become even more decisive. Anna Sukhotska, are you with us?
Yes. So
the floor is yours.
Thank you so much. Thank you so much for inviting me to this conference. Exactly, it's not the first time when I am taking part in the discussion on the legal system in Ukraine. Since years, I was involved in making opinions on Ukraine in this area. But today we exactly commemorate the very important date, which was the ratification of the European Convention of Human Rights. As it has been said, just we are doing it in a very set time. Yes, we never expected that such a situation, such an aggression of one country being a member of the Council of Europe against another country being a member of the Council of Europe would happen in the beginning of the 21st century. The Venice Commission condemned this aggression very strongly during its first plenary session in March. And then the Venice Commission also strongly pointed out that will support the Ukraine in its fights for the protection of shared European values like democracy, human rights, and rule of law. And it was the main goal of the Ukraine when Ukraine decided to make application to join the Council of Europe. As a consequence of being a member of the Council of Europe, which had happened in November 95, of course, it was also the membership, we can say, to the European Convention of Human Rights. It happened in 1997. So since 25 years, Ukraine is attached to the European values. The Ukrainian authorities have expressed since the beginning their determination to meet European standards and criteria that underpin true democracy. At the base of the drive to join the convention was a deep conviction to reverse the point of gravity in the process of protecting human rights, making the individual, the dignity of human, the point of reference and not the all-powerful state, what was the idea in communist era. Accession to European Convention was a clear indication of the need to create uniform human rights standards for both parts of Western and Eastern part of Europe. It required adherence to constitutionalism and making constitutional reform. In such a situation, the first step, which should be done by Ukrainians, was to make amendments to the constitution, to the old communist constitution, and then prepared completely new constitution. It was exactly a very difficult challenge, very difficult task, because there was a lack of real, it has been also mentioned here today, of real political culture, which could have been rooted in long-lasting democracy. It was impossible. So Ukraine needed help. And in such a conditions, the Venice Commission has been established. When the idea to establish such a commission in the end of 80s was done by famous Italian constitutionalist Antonio La Pergola, there were some doubts concerning the need for such a new body in the Council of Europe. But it was why was I can say the main doubts, because constitutional law was perceived as clearly linked to national sovereignty. As states were reluctant to establish an international body which could interfere in constitutional issues. But when the communist system collapsed, it became obvious that the new countries need help. And in this situation, the role of the Venice Commission was so important. And even I can say now, after so many years, it is still important and even probably more important. Ukraine has become a member of the Venice Commission since February 1997. So it was also, you also have a certain jubilee to be a member of the Venice Commission. One of the fundamental process at the beginning of the transformation was the process that could be called the discovery of the elements that make up the concept of the common European constitutional heritage. In this concept, the role of the Venice Commission became extremely important. The Venice Commission helped the countries to discover what, growing out of the common European legal tradition, become a European legal standard. Therefore, in the general category, the so-called European standard was perceived as a central value. And now very often, making our opinion, we are calling the European standards, as it has been mentioned here also, created by European Court of Human Rights, but also in big part by the Venice Commission. Venice Commission has been actively involved in the process of democratization in Ukraine, especially in the process of amending and drafting the Ukrainian constitution. And we can remember here that the Venice Commission was involved in the work even before the Ukraine became a member, formal member of the Venice Commission. Already in 1993, members and experts of the Venice Commission submitted written comments on the draft proposed at the time and held an exchange of view with its author. In 1995, the Commission adopted an opinion on the present constitutional situation in Ukraine, following the adoption of the constitutional agreement between the Supreme Rada of Ukraine and the President of Ukraine on the basic principles of the organization and functioning of state power and local self-government pending the adoption of the new constitution of Ukraine. And then the Venice Commission made also comments on the preliminary draft for a new constitution submitted in 1995, and held exchange of views with the group of legal experts entrusted by the Constitutional Commission with the task of drawing up a revised draft. And finally, the Venice Commission gave its opinion on the new constitution. This opinion was adopted by the Commission in March 1997. In this opinion, Commission strongly pointed out the positive solutions concerning human rights and its compatibility with the European Convention. It has been said in the Venice Commission opinion that it should be noted that the catalogue of rights protected is very complete and that it shows a willingness to protect the full scope of rights guaranteed by the European Convention of Human Rights and to ensure that these rights are implemented in practice. Of particular importance are also Article 8, Paragraph 3 and Article 55, Paragraph 1, provided that human rights are directly applied and protected by the courts. It was important and it was pointed out in the Venice Commission opinion. And Ukraine decided to introduce to the constitution a clear fundamental principle on the separation of powers. The main challenge in the light of this principle, which should be taken by the Ukrainian authorities, was to find the best guarantees for independence of the judiciary in the line with Article 6 of the Convention. And we can say that here is always our discussion since years concerning how to, in the best way, guarantee the independence of judiciary. I can even recall here that the Venice Commission prepared more than 110 opinions on Ukraine, on different draft laws and draft of constitutions in Ukraine, and more than 20 opinions only on the judiciary. So it is exactly a huge work which has been done by Venice Commission, but also a very effective cooperation between Ukrainian governments, I can say, because it was in different epoch, and Venice Commission. The Venice Commission opinions were in full compliance with the jurisprudence of the European Court of Human Rights. Because, as I said, the basic principles concerning judiciary were spelled out notably in the case law of the Court of Human Rights, but also in the different opinion of the Venice Commission. I don't like to mention here the general principle, but what is very exactly important, it has been pointed out very strongly, that the court, within the meaning of Article 6 of the European Convention of Human Rights, must satisfy a series of different conditions. The independence of the members and the length of their terms of office, the security of their tenure, impartiality and the existence of procedural safeguards against outside pressures, that the tribunal must also be given an appearance of independence. More detailed standards came from the Committee of Ministers, from the Consultative Council of European Judges and other institutions. In this process of reforming judiciary, there were many difficult points that had to be overcome. One of them was, paradoxically, the problem of lustrations and vetting procedure of judges, because in the beginning, the constitutionalization of the standards of the independence of the judiciary has resulted, as I said, in paradoxical situation, because the guarantees, notably of irremovability and of the establishment of the High Council of Judiciary, competent for the recruitment, the career and dismissal of judges, have been bestowed upon judiciaries which were not yet fully independent and impartial. These guarantees have in fact turned out to be hopeless to achieving an independent and impartial judiciary in the first place, as Ukraine has experienced. It shows the discussion on the lustration and vetting laws. The Venice Commission was exactly strongly involved in the process of making lustration laws. Attempts to lustrate the judiciary have therefore been made not only in respect of the communist ideology, but also in respect of corruption and incompetence. It was also mentioned today by President Anticosti. The two aims, combating corruption and ensuring professionalism, require different means. Specific anti-corruption mechanism, including, like in Ukraine, asset declaration justifying the origin of property for the first, but then professional competition for the second. But these tools risk failing, and the dismissal of the disciplinary sanction must ultimately be decided by a professional body, which itself dominated by corrupt or incompetent judges. So it was a very, as I said, difficult point, how to put together the situation of existing corrupted and non-partial judges with the constitutional role which established the judges, but as an independent person, an independent body. Public trust to judiciary was very low. Lack of confidence in the court is a dangerous phenomenon that can jeopardize any chance of democratic development. Corruption, as it has been said many times, is the sand in the gears of any reform. Democracy must be able to defend itself. And so for that reason, the reform of judiciary was and still is such an important task in Ukraine, but also in some other states in the former communist regime. But what are the basic challenges today? One of the basic questions today we can hear in several countries is a question concerning the role of universal standard, European standards under the European Convention and a uniform system of protection of human rights. We can hear exactly the voice making such a point of reference to the concept of margin of appreciation. This concept is intended to leave states some room for legal maneuvering. However, and this should be clearly emphasized, within the framework of the convention, not outside it, because some countries now try to use the concept, making interpretation outside or even contrary to the convention. Admittedly, there have been doubts in the literature whether it does not relativize the foundation of the common European system of protection of individuals, this concept. However, it seems that there is no such danger, as evidenced by the fact that from a concept developed by case law, by court, it became a concept, or maybe we can say rule, introduced in an additional paragraph to the preamble of the convention as a result of the adoption of additional protocol 15 to the convention. But this concept should not destroy the unity of the convention. And the concept gives the flexibility needed to avoid damaging sometimes confrontations between the European Court of Human Rights and the member states, and enables the court to balance the sovereignty of member states with their obligation under convention. The key point is that this concept does not overrule the uniform standard, and so it should be strongly pointed out. The principle, it means the principle which have the character of axioms rooted in the European legal traditions and grounded in Strasbourg jurisprudence that must be strictly observed. For they are the ones that form the system, the backbone of the entire legal construction. And it is the right to a trial, right to a fair public hearing, and the independence of judiciary. The convention, as it said, we mentioned also here, is the most effective instrument for the protection of human rights that has been adopted in international law. In order to be able to perform this role by convention, certain duties have been imposed on states. And exactly, it is the duty of state parties since the ratification of the convention to ensure, in accordance with the principle of subsidiarity, that the rights and freedoms under the convention are respected in the country. We had the very detailed presentation done by Mr. Tretakov on how the problem is there in Ukraine. One of the important key issue here for assuring the effectiveness of the European human rights protection system is the effective enforcement of Strasbourg judgment at the national level in the country that lost the case. However, the European Convention has not enforcement instrument of its own, relying entirely on states parties to the European Convention in this regard. This essence of the European Convention construction, of which the court is an emanation, is the primary responsibility of states to enforce judgment. And now, what is exactly important when we would like to think on the European Convention and on the mechanism coming from European Convention in the future? What has been done? Fundamental change have been made in the domestic law, also on the level of the constitution being in line with the European standards. It has happened also in the Ukrainian system. Guarantees of human rights has been introduced to the law, especially the right to a court, including the right to refer a complaint to the European Court of Human Rights. The argument about the possibility of referring complaints to the Strasbourg bodies was one of the important points in the debate on ratification of the convention. The convention, therefore, provided a model for a human rights guarantee system. In fact, it was established that the threats to human rights are rather not so much due to the lack of substantive right just now, but to the lack of procedural guarantees, insufficient access to an impartial and independent court. The standard of implementation, not standard setting. This was also strongly emphasized in many Venice Commission opinions and also in a report on the rule of law checklist and in the report on independence of judiciary. Then, the right to make complaints to the European Court is widely used by Ukrainian citizens. Maybe you will be able to give us much more detailed statistics. I have such statistics, I read such statistics, that Ukraine is the country from which the largest number of complaints comes from. The situation has existed since the beginning of 2014. In the statistics, Ukraine has overtaken Russia then in 2014. Maybe it should be verified now. The crucial is the regulation in Article 46 of the Convention saying that states are bound by the final judgment of the court in all cases to which they are parts. These regulations made the right of appeal to the Strasbourg bodies a real right, not an illusory one. And here the question arises, where we are today, 25 years after the ratification of the convention in Ukraine. One of the crucial, but also very dangerous questions, which is now strongly discussed and even implemented in several countries, is the questions regarding the binding force of the European Court rulings and implementation of these rulings. And sometimes, as an argument, is taken this concept of appreciation, as I said about. One gets the impression that in some countries there is an attempt to revisit the issue from the turn of the transition that have been resolved in judicial practice regarding the binding effect of ruling of the convention bodies in domestic law. This was done by Russia as early as 2016, and now it's pity for me, but it also has been done by Poland. Judge and current president of the International Criminal Court, Hofmański, wrote in the early days of the transition that the convention, in addition to explicit law, also includes human rights standards developed by the European Court of Human Rights. Of course, these standards became real only when they are actually applied, and their application requires knowledge of them. And it is jurisprudence that, to an important extent, provides protection against the devaluation of the standards themselves. But here, I think, it is exactly a very important question which has been put by Judge Henatovsky on the role of the judgments of the European Court as a sources of law. This is probably the point for the further discussion. It should be taken into account that probably exactly the development of the judgment is also important. But ignoring of the judgment leads to politicization sometimes and instrumentalization of the law, which is a negation of the rule of law and the whole European legal identity rooted in the European Convention. To deny the binding force of European court rulings in domestic law is to open the way to a cancellation of the guarantees of the right to a court under the European Convention, and at the same time to a cancellation of the importance of the Convention in the domestic legal order. We have returned to the position that prevailed under the previous system, that it is the political authority of a country that decide the international acts and rulings of international bodies, despite formal accession to and a ratification of a treaty, would be binding on the country. This is a reversal of the obligations incurred as a result of ratification of the convention. And in the end, I would like to say that at the time of the enlargement of the Council of Europe and the accession to the European Convention, it was made clear that it could not be its consequence to succumb to pressure aimed at weakening standards with regard to the right to an independent and impartial court. Nor it is possible to take the position of permanently accepting the separate value systems that will apply within the Council of Europe to right to an independent court. It is worth maybe here quoting the words expressed a few years ago by Professor Jawiecki, who was also a substitute member of the Venice Commission. He said, "It is to be hoped that the values and approach that Eastern Europe can bring to the Council will not weaken but strengthen and revitalize its goal of building a common Europe for its people." The words are of great value today, and we are discussing the whole hour round table today is devoted to this role and to this future. Thank you so much.
Дякую. Ми маємо рухатись
Thank
далі.
you. Let's move on. And now I'm giving floor to Jeremy McBride, a well-known expert and international consultant who is with us today at this round table under the support of one of the Council of Europe projects, which is dedicated to supporting human rights in the system of criminal justice of Ukraine. Jeremy McBride, same as other speakers from the Council of Europe. He is our permanent expert for Ukraine, mostly in criminal justice, and he knows how Ukraine developed over the time and what kind of developments Ukraine has over these 25 years. Over to you, Jeremy.
Thank you very much, Irina. I'm very pleased to be able to join you today, and pleased also to see amongst the participants many of the people with whom I've worked over the years. I was also touched by Mr. Kostin's reference to the book edited by Olga Sukowska, and the training that was done many years ago. One thing that we neglected in that training was to talk about the convention in time of war. Undoubtedly, it didn't seem at all relevant then. The situation has changed quite significantly. But there can be no doubt that the drafters of the convention were conscious of the relevance of the convention in times of war. You see a specific reference to it in the provision on derogation in Article 15. It was also mentioned in Protocol 6 in relation to an exception to the death penalty before that was removed by Protocol 13. But the text of the convention is not the only thing. It's also affecting the work of the court. It's been estimated in 2021 that some 15% of individual applications have arisen out of interstate conflicts, which is a significant part of work. There has been a body of case law that's developed, but that case law is not entirely clear or satisfactory. And undoubtedly the current aggression will give rise to a need both to revisit some of the conclusions and decisions which have been reached in the past, and also to address some situations which have yet to be given significant consideration by the court. The potential relevance of the standards of the convention in times of war might be best considered in two sets of circumstances. Those that might be seen as being in some way connected to the conduct of hostilities themselves, and those that result from the existence of the conflict, whether to facilitate its conduct, to prevent these from being undermined, or to secure the life and well-being of those who are not participating in the hostilities. As regard the first set of circumstances, there are two aspects. That is to say, at least as from the point of view of the court, those when the hostilities are seen as active, and others when that is not the case. The concept of an active phase to hostilities was developed by the court in Georgia and Russia #2, a conflict which lasted for just 5 days. This was then followed by an occupation phase with the conclusion of a ceasefire agreement. Such a neat beginning and end, of course, is not a feature of all conflicts, and the appropriateness of this concept seems far from compelling when a conflict is prolonged and virtually all-encompassing in its impact on the high contracting party that is the object of an unprovoked attack. But assuming that that concept still has some relevance, the majority of the court attached much to the idea that you had problems of establishing control over an area in a context of chaos, and therefore there was no either effective control over the area or any form of state agent authority and control over individuals. And thus it reached the conclusion that there would be no exercise of extraterritorial jurisdiction, allowing responsibility to be applied. In reaching this conclusion, the court's reasoning was supported by the practice of high contracting parties in not derogating under Article 15 in situations where they had engaged in international armed conflict outside their own territory, suggesting that they do not regard themselves as exercising jurisdiction within the meaning of Article 1 of the Convention. This conclusion was also influenced by the large number of alleged victims, the contested institutes, the magnitude of the evidence, and the difficulty establishing the relevant circumstances. Suggestions which might lead to the fact that the court didn't want to face the difficult task which was involved. But the emphasis on the extraterritorial nature of the conflict is problematic in this case, since this was not the situation facing the other party to it, that is to say, the applicant state. And also, the court, in reaching its conclusion, relied heavily on its admissibility decision in Bankovitz and others against Belgium and others, and ignored yet that the essential point made in that case, that the convention was a multilateral treaty operating in an essentially regional context, and notably in the legal space of the contracting states. It is hard to understand the view of the European Court that the convention can have no relevance to the devastation caused by one high contracting state to lives and property of those living in another high contracting state. In addition, the notion of a context of chaos might not be an appropriate assessment of a situation where there is relentless bombardment by one party of the convention, particularly if there is a use of disproportionate firepower. Furthermore, the point about the practice of non-derogation is questionable, given the express terms of paragraph 2 of Article 15, providing for the possibility of derogation from Article 2 in respect of deaths resulting from lawful acts of war. The implication of this provision is that without a derogation, even such deaths would be inconsistent with the right to life under Article 2. Moreover, by effectively legitimizing the practice of non-derogation, the court might be seen as having undermined the role of the derogation procedure in enabling other contracting parties to determine whether the measures taken have led to violations of convention rights and freedoms. Nonetheless, the absence of derogations relating to the use of force in the course of armed conflict is concerning. Only Armenia and Ukraine have notified the Secretary General of the Council of Europe of derogations from the provisions of the Convention as a result of the conflicts in which they become involved. But these derogations deal with the imposition of martial law and the mobilization of armed forces. They did not or do not make any derogation regarding Article 2 in respect of deaths resulting from lawful acts of war. Finally, the resort to the jurisdictional escape route seen in the Georgia-Russia case not only allowed the European Court to avoid dealing with the situation of the alleged victims of acts and omissions by the respondent state, but it also meant that it did not have to consider the very legitimacy of that state's resort to the use of force. Although this is primarily a matter for the application of the United Nations Charter, it is well established that the European Convention should, so far as possible, be interpreted in harmony with other rules of international law, of which the Convention forms part. Thus, insofar as a contracting state is enacting in a manner contrary to its obligations under international law as regards the use of force, it is difficult to see the justification for concluding that consequences thereby produced, which are inconsistent with rights and freedoms under the Convention, cannot be a matter that does not entail responsibility under the Convention. In this connection, in revisiting its case law, the European Court might therefore find it appropriate to follow the lead of the United Nations Human Rights Committee in its general comment number 36 on the right to life. In this, it concluded that states parties engaged in acts of aggression, as defined in international law, resulting in deprivation of life, violate ipso facto Article 6 of the Covenant, Article 6 being the guarantee of the right to life, and that states parties that fail to take all reasonable measures to settle their international disputes by peaceful means might fall short of complying with their positive obligation to ensure the right to life. This, it seems to me, is something which the court will need to bear in mind when dealing with some of the cases which arise from the present conflict. As regard conduct outside the active phase of hostilities, insofar as that is a realistic notion, the relevance of the rights and freedoms of the European Convention has not been put into question by the court, with no jurisdictional obligation being raised. Thus, it has found violations of Articles 2 and 8 of the European Convention and Article 1 of Protocol Number 1 as regards the killing of civilians and the torching and looting of houses in territories under the effective control of Russia, even though those acts were not attributable to its own soldiers. Equally, the court has found a violation of Article 3 as regards the conditions in which civilians have been detained and the infliction on them of humiliating treatment. Furthermore, the detention of civilians purportedly for their own safety was found by the court to in fact amount to arbitrary detention, not only because the reason was disputed, but also because they had not been informed of the reasons for their arrest and detention. This deprivation of liberty was, however, distinguished from the redness in Hassan and the United Kingdom to regard the arrest of a combatant as not amounting to a violation of Article 5, notwithstanding that it did not come with any of the categories allowing for detention in Article 1 of that provision. In the court's view, in cases of international armed conflict, where the taking of prisoners of war and the detention of civilians who pose a threat to security are accepted features of international humanitarian law, it took the view that Article 5 could be interpreted as permitting the exercise of such broad powers. This conclusion of the court again dispensed with the need for a derogation, but in doing so, the European Court did still expect some protection against arbitrariness, albeit in a watered-down form of Article 5, paragraph 4, namely with the competent body providing sufficient guarantees of impartiality and fair procedure to protect against arbitrariness. Moreover, it specified that the first review of detention should take place shortly after the person is taken into detention, with subsequent reviews at frequent intervals, to ensure that any person who does not fall into one of the categories subject to internment under international humanitarian law is released without undue delay. In the Georgian case, the European Court was also prepared to consider that the ill treatment of prisoners of war should be regarded as a violation of Article 3, even though this is something also regulated by international humanitarian law. In addition, the The inability of persons to return to their homes was seen as a violation of Article 2 of Protocol number 4. And following several other cases involving armed conflict, there was found to be a violation of Article 2 in the procedural aspect in respect of deaths occurring both in the active and occupation phases, where the investigations carried out were neither prompt nor effective nor independent, as required by Article 2. In all cases where the Convention is clearly applicable, there will be a need to substantiate beyond reasonable doubt that any allegation of violations of rights and freedoms has occurred. And thus, in the Georgian case, for example, the court was not satisfied as regards the looting claims relating to the looting and destruction of public schools and libraries, as well as the intimidation of ethnic pupils and teachers. If the evidence had been more convincing as far as the court was concerned, then there would have been a violation of the right to education under Article 2 of Protocol number 1 and possibly other provisions of the Convention. Finally, in terms of this part of the application of the Convention, it's important to bear in mind the duty of cooperation that there is under Article 38 of the Convention in terms of providing information. And in the Georgia-Russian case, there was found to be a violation by Russia when it refused to hand over information about the conduct of its combat missions, whereas there had been full cooperation or fairly full cooperation by Georgia. And so it was possible to determine that activities that it had undertaken were not those responsible for the destruction of homes and other property. As far as a situation where you're dealing with outside the direct conduct of hostilities itself, there is no case law of the European Court concerned with the measures during a war that involve exceptional restrictions on rights and freedoms directly concerned with the war. But there is a well-developed body of case law concerning taking of measures in response to an emergency situation developed where pursuant to a derogation under Article 15. And this case law provides important guidance as to the measures that are taken, therefore, outside the conduct of hostilities and what might be legitimate. But those measures will only be admissible if the derogation complies with the requirements specified in Article 15. These are procedural ones, namely informing the Secretary General, and also substantive ones regarding the existence actually of a war or state of emergency and its inapplicability rights that are non-derogable. Moreover, any measures that are taken must be strictly required by the exigencies of the situation and must not be inconsistent with other obligations of the Convention. Notifying the Secretary General requires a timely notification of the measures taken, as well as sufficient information. And allowing lengthy periods, such as 3 or 4 months, for example, will be seen as unacceptable, whereas shorter periods of a day, 12 days, and perhaps even a month are likely to be unproblematic. But it must also be, the issue of procedure must also comply with other obligations under the Convention, and therefore, there is a need for any derogation to be officially proclaimed. This was an interpretation relied upon the obligation specifically provided for in the International Covenant. The substantive requirements in Article 15 are fourfold. There must be a war or a state of emergency. The measures must not affect non-derogable rights, and the measures must be no more than strictly required or inconsistent with other obligations under international law. The notion of an emergency is the issue which has been addressed by the court as being an exceptional situation of crisis or emergency affecting the whole population and constituting a threat to the organized life of the community of which the state is concerned. It is difficult to imagine that this could not be an apt description for a war, at least where the war is taking place on the territory of the state concerned. It might not be so appropriate where conflict is taking place outside the territory of any conflicting state. The non-derogable rights are clearly set out in the Convention, but again, those non-derogable rights might well be enhanced by the relationship with other obligations under international law. The European Court itself has seen Article 5, Paragraph 4 of the Convention, which concerns the right to challenge the legality of detention, as something which could be subject to a derogation measure. It did so reach that conclusion in the Ireland and UK case. But the UN Human Rights Committee has taken a different view and regards, in effect, that a derogation under Article 5, Paragraph 4 would not be admissible. And it may therefore be that there will be a need for that aspect of the case law to be revisited because the Convention and the Covenant apply to the parties concerned. In terms of measures that are strictly required, this obviously requires a judgment to be made about the particular circumstances and the effect that those measures have. Particular measures which have been seen as acceptable are certainly ones which involve deviating from the ability to bring a person before a court after apprehension in the context of criminal provisions. The promptness notion has been become slightly more elastic. There have also been the possibility of detention without trial in the case of some circumstances. And it will also be the case that there may be justification for interference with the right to the home, the right to worship and freedom of expression, and the freedom of peaceful assembly. But it must always be demonstrated that those restrictions are ones which are actually needed to deal with a particular problem, and therefore there is a burden on the state to justify that. Moreover, where restrictions are imposed, it is clearly crucial that there be safeguards against abuse. And this was emphasized very strongly in relation to deprivation of liberty, for example. If you look at the case of Brannigan and McBride, you see there that even though there might be delay in bringing a person before a court after his or her apprehension, there is a need for the continuing availability of a habeas corpus or similar remedy so as to ensure that any allegation about illegal deprivation of liberty is open to challenge. It's also clear, I think, although there's been no case law to support this, that delay in the conduct of proceedings, contrary to the reasonable time requirements under Article 6.1, are likely to be acceptable, although the need is to work out whether or not extensive delay is justifiable. And where it's possible to make alternative arrangements, such as we've been hearing about in the earlier interventions today, it's clear that you cannot say that it will always be justified to have delays in terms of the length of proceedings. It's important that any restriction on rights and freedoms under the Convention must be consistent with the law. And we've heard extensively about what the idea of law means. But one point which is particularly important in this present context is made clear in the context of emergency, is that the derogation measure must also be consistent with the Constitution. This was an issue which arose in a case against Turkey, the Mehmet Hasan Altan case, where the Constitutional Court of Turkey reached the conclusion that the right to liberty and security in the Constitution would be meaningless if it were accepted that people could be placed in pretrial detention without any strong evidence that they had committed an offence. And so the absence of reasonable suspicion for a deprivation of liberty was seen as unconstitutional. Given that it was unconstitutional, the European Court therefore came to the conclusion that it could not be consistent with the Convention for such a deprivation of liberty to take place. And therefore, there was a violation in that respect. And it's important, therefore, when looking at the question of the law, always to make sure that you are acting in accordance with your constitutional standards. The final point I want to make is that even where there is a war or other emergency, the fact that there is no derogation or one which is not as comprehensive as should have been made will mean that you cannot invoke that situation to justify additional restrictions on rights. If the derogation does not cover the particular problem that you are seeking to deal with, in those circumstances, that will be a violation of the Convention. And a very recent illustration of this point can be seen in a case against Switzerland, which was concerned with a ban on the holding of public assemblies connected with the crisis posed by the COVID-19 pandemic. Switzerland, unlike many other states, did not make a derogation in this case. and therefore it could not rely upon the emergency which COVID caused to justify the restriction on the holding of a blanket restriction on the holding of public assemblies, and therefore there was a violation of the convention. So I hope this gives a sense of how, in many different ways, the convention will have direct relevance to the conduct of war and the consequences of war for those who may be affected with it. It remains really very alive and pertinent. Thank you very much.
Дякую вам, пане Джеремі.
Thank you very much, Jeremy. Our today's event does not suggest that there's going to be a question and answer session. However, if you have such questions, I would suggest that everyone put those questions in chat. Our interpreters, I think, will help us translate the questions, and the participants can get answers to their questions, as we heard a lot about the case law from Mr. Tretyakov, from Mr. McBride, from Ms. Sukhotska. Thank you very much for having made such a large-scale review of the Venice Commission opinions, but we have to keep moving. And now I have the honor of giving the floor to the Secretary of the Grand Chamber of the Supreme Court, Larissa Rovich, who's going to talk about the role of the Supreme Court in the implementation of the European Convention of Human Rights. Larissa, are you with us? Yes, I'm with you. Thank you for the invitation. I'm very happy to see all the present here. Good afternoon to all of you. A peaceful day and good health to all of you. It was very interesting to listen to the previous speakers, especially because what we see in Article 6 of the Convention, the right to a fair trial, has a direct practical meaning for the work of the judicial system in general and the Supreme Court in particular. In fact, we're dealing, first of all, with the additional guarantees of independence and possibilities to bring back the trust to the judiciary that previous speakers spoke about, because I believe that the understanding by the society of the fact that they need to correlate their activities with the general European standards, and that the decisions that are made by the Supreme Court or any other court within the judicial system will be reviewed or may be reviewed, and the European Court of Human Rights can speak about them to see whether the convention has been complied with. This can also help bring back the trust of the judicial system. The things that I would like to cover, we have had it in the work of the Supreme Court, but I'm going to focus on certain issues that we had in the that we faced at the Grand Chamber of the Supreme Court, because for procedural reasons, it so happens that the Grand Chamber has, well, mostly faces the issues related to the application of the Convention and therefore the case law of the European Court. This is related to several factors, in particular to the fact that the cases often get to us that have an exclusive legal problem. These are the cases related to disciplinary liability of the judges, and the decisions of the Grand Chamber, in fact, would then have to be checked by the European Court to see whether any violation has taken place of the rights and freedoms of the participants of the cases. And the Grand Chamber also reviews, under exceptional circumstances, of the decisions of the national courts if the International Court finds a violation of the Convention that we're discussing here. I would also like to note that even during that relatively short period of time that the Grand Chamber has been working at the Supreme Court, we have already felt some changes in the understanding of the conventional rights that are taking place now. When we started our work, we mostly talked about the negative rights, that the government cannot interfere with certain rights guaranteed by the Convention. Now, in the recent years, well, in this year or two of our work, we have been dealing with positive obligations of the government, namely with those cases where a legal person or a physical person believes that the government should have guaranteed the right, should have given one the right to implement one's rights and to provide proper legal remedies. In other words, these are positive obligations. Let me try to focus on certain issues as to how the Grand Chamber, which embodies the judicial system and the Supreme Court, has tried to implement those main principles and standards to be found in the Convention. First, to speak about a fair trial and independent court established by the law, we need to reach the level where a person, when coming to the court, would know for sure to which court one should go, with account of the fact that the judicial system is variegated in Ukraine. And it was also very important for us to identify which cases that the person brings to the court are among the category of disputes that are to be heard by the judiciary, and which of the cases that would be submitted to the courts can only create an illusion of a dispute. On that decision, if we could make such a decision, that would mean we could reduce the number of applications admitted by the court in order to better focus on the protection of the rights. In other words, the work that the judicial system should perform. This also is aimed at cutting down the number of applications to the European Court, so that people would feel that their rights are properly protected by the court, and therefore one would get the judgment that is enforceable. That is also a very important part of our work, so that the person would not have to have one's right enforced, to turn not once but 2 or 3 times, and to get the decisions of declarative nature that can be very well written, that can comply with all the well-established standards and have just one little flaw. They cannot be enforced, and the person would not be able to get what the person had asked from the court. During the time of our work of the Grand Chamber, we have permanently performed some work to differentiate between the jurisdictions of the disputes between the civil, administrative, commercial courts. Sometimes these issues were also important to see whether a case was to be heard within a criminal trial. In fact, to do that, we introduced such a category as, unlike the parties to the case, we talked about parties to a dispute. And that means that regardless of how a party would decide who the respondent party is, we have to understand what the conflict is about and who it is with. Who is a party to the dispute, to the legal dispute in a certain situation. The use of this principle helped us avoid the possibility that parties would abuse their rights, in particular in those cases when by artificially forming different respondents, the parties would turn, and we have had such situations, first to a civil court, then a commercial court, then an administrative court, in fact, requesting that the final decision would be reviewed, contrary to the principle of legal certainty. We have also had cases, and in fact we paid our attention to it by the Grand Chamber, that the parties would turn to the court not with a request to find a solution, but rather to create a prejudicial, to establish a fact on the basis of which they would have a chance in the future to initiate a dispute at another court proceeding. Unfortunately, we have had quite a lot of such cases, and in fact, we paid attention to it in our work. As I have said, we also paid our attention to clearly orient the parties to the different remedies that would allow a person to be able to be protected by going to the court just once and getting the decision, the judgment that would be enforced and would convince the person that the judicial system is effective and the decisions of the judiciary are really aimed at protecting human rights. I would also like to draw your attention to the fact that in the process of our work, we faced a situation of jurisdictional conflicts. In other words, when the impossibility to hear a case within a certain jurisdiction, that's what the judge of one jurisdiction would say, for example, a civil court and then a commercial court, sometimes even an administrative court as well. Because of that, the Grand Chamber introduced the rule saying that a person may not stay unprotected, and therefore one should not suffer from the fact that the judicial system at a certain period of time has not identified which court would be the proper one. In such cases, the Grand Chamber said that if the applied procedure does not violate procedural rights of the person, then, let's say, where in a specific case that I'm describing now, if there is a refusal of an administrative case to hear a case that was to be heard within the administrative law, in that case, we cannot force the person to once again go to the administrative court, but the case should be heard by the court in which, as suggested by the administrative court, the person had initiated the proceedings. In that way, the Grand Chamber implemented the conventional safeguards in terms of access to the court, which is very important, and to make it jurisdictional conflicts impossible when different jurisdictions would play this kind of a table tennis in terms of a party that is requesting its protection. We also worked to draw the attention of the judges of the lower instances on the need to increase the motivation of their judgments by using the three-tier test suggested by the European Court of Human Rights, as well as the use of the case law of the European Court. I'd like to underline that we were not talking about a mechanical copy-pasting of the judgments of the European Court, which may be applicable to the circumstances of the case. We suggested that the circumstances should be identified with the use of the approaches, primarily the approaches applied by the European Court to hear such categories of cases. Well, I can give you some examples. In the cases dealing with interference with the property rights, as well as the right to access to public information, the Grand Chamber of the Supreme Court studied to see whether such interference was lawful, whether it had a legitimate objective, relied to the convention, whether it was necessary in a given situation, whether the government could reach the same objective in other ways. In other words, whether the interference was proportionate. We heard very interesting cases from the case law of the European Court. I think it may also be interesting for you to hear about some cases heard by the Grand Chamber. In particular, we had a case where the defendant, and the defendant was the president of Ukraine, refused to provide to some information, the information about which, as the applicant believed that the president had. As we heard the case, the Grand Chamber of the Supreme Court based itself on the opinion that as the applicant received a refusal in receiving this information, which said that the information was not of public nature, and also take into account that the applicant had some information about the defendant who probably had that information. The Grand Chamber believed that the refusal has the elements of interfering with the right of the applicant according to Article 10 of the Convention. At the same time, the Grand Chamber believed that it was necessary to check whether that interference was lawful, whether it pursued one or several legitimate aims that can be found in paragraph 2 of Article 10, and whether it was proportional. Having checked all those circumstances, in other words, by applying a test, the Grand Chamber of the Supreme Court said that providing to the applicant of the information that was asked about the third persons who he did not represent and that he personally did not have any relation to them would have meant unjustified interference of the applicant in the rights of those participants of the actions of protest, that information about whom he wanted to receive, and that refusal to provide access to the information would be proportional to the aim of protecting the rights and freedoms. Although there were certain doubts either whether the president, whether the defendant could have that information. However, providing this information in the form of printouts of all the conversations between the participants of the actions of protest would have been unjustified interference in the right of those persons to privacy. This is how we applied Article 10 of the Convention. We also considered the three-tier test when we dealt with the issue of peaceful property rights, in particular when, for example, some persons received land that the legislation of Ukraine called the public land and was to be protected in special ways. So we considered the issue about whether in that case it was legitimate to have an interference in the right to own a disputed plot of land by a specific natural person. The Grand Chamber stated that in that case, natural persons who had taken those plots of land could not but know that there was a legislative ban on carrying out such actions as to certain categories of land, and therefore it was a prohibition to use them with the purpose for which they had received them, namely to build houses there, stating that it was not a bona fide idea that those persons had taken, which were to remain public. It was considered that in that case the interference of the government was legitimate. Unfortunately, I'm limited in time, and I would also just like to draw your attention to a number of problems that we had as we applied the Convention of Human Rights and therefore the case law of the European Court in our work. First of all, here we're talking about how one can use the acts of international law and how procedurally the international law was implemented in the national law via a certain procedure. What am I talking about? The procedure established by the legislator in order to review the decisions because an international institution has decided that it did not comply with the convention. So the procedure is to review the decision under exceptional circumstances, but the time frame during which such an application can be submitted is limited to a certain period of time. For Ukraine, this is 10 years. And in fact, such a time frame exists in other countries as well. And I would say that for Ukraine, 10 years, from what we have seen, is perhaps the longest time frame. It is preclusive, which makes it impossible to further apply to the court asking for a review, and this is in line with the principle of legal certainty. At the same time, because of a large number of applications by the citizens of Ukraine to the European Court of Human Rights, we could see the situation, we could see it many times, where applications to the court asking for a review would be outside of the deadline. And therefore, the question was whether in such situations we can directly comply with the requirements of the law, saying that the decisions are to be reviewed with the current procedure that we now have in the legislation for it. In fact, in the case related to a person dismissed from one's position, we said that the time frame or the period of time during which one could ask for a review had already been provided by the Grand Chamber of the Supreme Court, namely 10 years, and the expiry of that time frame was not related to the fact that they had not applied to the court, but were also related to the lengthy proceedings at the European Court of Human Rights. And we came to the conclusion that in that case, we had to review the decision because it was an exceptional situation where the dispute was of legal nature. It was related to protection of the rights and freedoms of natural persons against the government. So although there was a legislative prohibition, in fact, we interpreted the deadline in that way. In the same way, perhaps the situation would require a legislative solution in order to remove the problem. And I would also like to draw your attention within the context of this presentation to certain cases when the Grand Chamber of the Supreme Court, within reviewing the decision, the judgments, stated that violations found by the European Court of Human Rights were related to the general measures, and such general measures were to be adopted by the government rather than by the court while reviewing the decisions. We're talking about Petukhov versus Ukraine, namely about life sentence. In that case, the European Court said that punishing the applicant in the form of a life sentence is such that cannot be cut down. And that means that there is a systemic problem to solve which some general measures are required. By considering the application by Mr. Petukhov, the court said that the nature of the violation under Article 3 means that for a proper implementation of that judgment, the system of penitentiary sentences would have to be reviewed. So in that case, there is a systemic problem in the Ukrainian law that can be overcome with the general measures aimed at removing the roots of the problem by changing the current legislation and the practice of its application, while only reviewing the decision, the Grand Chamber could not do that. I wanted to tell you many more thanks because the subject is very interesting, but thank you for attention, and I hope that my presentation could be useful.
Thank you so much for this comprehensive explanation of the case law of the Supreme Court. Now, the convention mechanism, it's a very complicated and unique mechanism. There are experts who claim that this mechanism could be created only when it was created. And it's not possible to replicate this mechanism under different conditions. So we're talking about the effective system of protecting human rights. Then there is the national system that has its own actors and players, the court, the parliament, the government agencies, the legislation, then the supranational system, which includes the CHR, the Venice Commission. All of them operate with one purpose: to protect human rights and its fundamental freedoms. And by the way, it's important to mention another version, a hypothesis that the historians are talking about, that the forefather of the system was Herr Schlauperbach, who was born in the vicinity of Lviv, and his basic legal education comes from Lviv University. And that is one of the well-justified versions. People discuss it, and it is a subject of our pride, especially the pride of Lviv University. But in this system, in its entirety, there is one very important element without which the system possibly would not be as effective. So we are talking about the mechanism of enforcing the judgment, so executing judgments. So we are now transitioning to the final block of discussion, the execution of ECHR judgments. And I am asking Margarita Sokorenko to present, and she is from the Human Rights Ombudsman Secretariat from the Ministry of Justice. And she will talk about implementation of the or execution of the judgments. Over to you, Margarita. Thank you so much. Thank you for giving me the floor. Allow me to also thank you on behalf of the Ministry of Justice. Thank you for inviting me to take part in this gathering, and thank you for organizing this very important conference. And I'd like to thank the presenters for their reports, for their presentations, and for issues raised with regard to execution of judgments. I'd like to present about Ukraine's execution of CHR judgments in the context of impacts of full-scale aggression of Russia on this process. And we are facing this aggression since February 24 this year. The execution of CHR judgments, and many times presenters spoke about it today, it's one of the most important commitments, international commitments of Ukraine, in spite of the armed aggression, in spite of the complicated circumstances under which all the government agencies are functioning, and all the challenges which we all face. The execution of CHR judgments cannot be ignored or cannot be put aside as unimportant. The ministry takes a direct part in the execution of judgments by coordinating this process, specifically in the judgments versus Ukraine, where the court found violations, and the information of the Committee of Ministers of the Council of Europe with regard to execution of each and every judgment. Now, speaking about the history of execution of judgments, it dates back to 2001. So this is when the first judgment against Ukraine was made. And there are 664 outstanding judgments so far against Ukraine. And Ukraine was able to implement over 1,200 judgments of the CHR. Now, speaking about successes, Ukraine was able to get the success in the implementation of judgments by cooperating between all the branches of power, and also by close cooperation with the department responsible for executing CHR judgments and the Office of the Council of Europe in Ukraine, which give full support to Ukraine in all of these important execution measures. And they offer some expert-level discussions. They offer expert opinions and reports on the issues identified by the CHR in its judgments. And today, on multiple occasions, it's been stated that we are now working under the conditions of war and martial law. And there are so many important issues. The security is now a priority for the state. And today's circumstances impact the operations of all government agencies. Moreover, the full aggression of Russia has impacts outside Ukraine. It has spillover effects, as they call it, and that impacts cooperation with ECHR. On March 1st this year, the ECHR, considering the large-scale invasion of Russia, implemented a series of measures, including a temporary suspension of execution. And they also stopped, for the time being, issuing judgments and posting them on UDOC. So, based on all this, the process of enforcement and execution of judgments has slowed down. And the Ministry of Justice did not suspend its operations. And it is still a priority. And for the last 5 months, we regularly do everything we can to execute those judgments. And we keep the Committee of Ministers informed about the results. Early this year, the Committee of Ministers suspended oversight over execution of 20 judgments of ECHR versus Ukraine. Specifically, they suspended oversight in the following important cases, such as Lutsenko versus Ukraine. And in this group of cases, the ECHR noted violation of Article 3 of the Convention connected to placing the claimants, the defendants, into the cage, metal cage. And then Bochan versus Ukraine case number 2, where they found the violation of the rights of claimants for a fair trial during the hearing of the cases in the Supreme Court based on the initial judgment issued by the CHR. Then Dedish versus Ukraine case, I want to mention, where they found the violation of Article 8 of the Convention by Ukraine, connected to the fact that the government agencies were referring to the previous judgments in this case. They failed to analyze the individual circumstances in the case, and they introduced administrative supervision for 1 year against the claimant, which was in violation of his right towards respect to private life. And besides, they suspended oversight in terms of repeated cases, Zemyuk versus Ukraine, for instance, where the ECHR found violation of Article 8 of the Convention in connection with intervention with claimant's rights towards his home and private life and family life, because the cemetery was allegedly placed very close to his home, and that impacted his life. And there was another case of violation of Article 6 connected to failure to implement judgments of national courts with regard to burials at the cemetery located next to the house of the claimant. Then speaking about some key problems, some key issues that result in ECHR finding violations of convention. So failure to execute or prolonged failure to execute of national court judgments and prolonged proceedings in criminal admin cases, then ill treatment of individuals who remain under the control of the state. And we are talking about preliminary detention, and we are talking about ineffectiveness of investigation and complaints against ill treatment, and then poor conditions of stay of such people who remain in custody or already in the penitentiary institutions. And that includes transportation of such individuals and then provision of adequate medical help. That also is connected to failure to provide proper legal remedies in response to complaints about poor health services and prolonged proceedings and prolonged stay in custody. We mentioned these problems on multiple occasions today because they are system-related and structural problems. And failure to address those problems results in receipt of numerous new complaints by the CHR, and the CHR finding violations of the convention. Now, speaking about these comprehensive problems, we work on them. We want to address these problems, and for the last 5 months, we submitted information to the Committee of Ministers about the situation of our penitentiary system and the judiciary and how they operate under the conditions of the martial law in Ukraine. And speaking about the judiciary, that belongs to the group of Volkov versus Ukraine cases. And we informed the committee about the following. Under the conditions of war, the constitutional right of individuals for protection cannot be restricted, and the powers of judges cannot be suspended. If it's impossible to perform to administer justice by some courts, their jurisdiction may change. They may be relocated physically. So, and it's been already mentioned earlier today when someone spoke about the territorial jurisdiction and how it changed, because many courts, the court buildings, are located in the occupied territories. So to protect participants of the processes and the visitors, we suspended personal visits of citizens and citizens who are not participants of the trial. Now, speaking about other important things, the court sessions cannot be delayed. The sessions where they discuss extension of custody or detention. And also we informed the Committee of Ministers about temporary powers which were granted to the President of the Supreme Court of Ukraine and the State Judiciary Administration with the purpose of uninterrupted functioning of the judiciary under the conditions of full-scale aggression of Russia, which also was mentioned by Andriy Kostin in great detail when he presented. Speaking about the penitentiary system, that is yet another structural problem mentioned by the ECHR, and we informed about the number of existing and operational penitentiary establishments. We also informed the committee about the number of evacuated inmates, the number of establishments which were damaged, and also we provided some other general information on this topic. I must mention that the functioning of the penitentiary system in the conditions of war is not just a problem for enforcement of ECHR judgments. In March and in April, we were having very active communication with the ECHR to discuss these very issues in the context of positive obligations of Ukraine and compliance with the rights of inmates who remain in the occupied territories or in the areas of active combat. Right now, we are working on another message about the execution of judgments, which relate to other issues, namely effective investigation of complaints, civil treatment by law enforcement. That's Kaverzin versus Ukraine group of cases, and then the issue of failure to enforce the judgments of national courts in Ukraine. That belongs to the group of cases Ivanov, Burmach versus Ukraine. And this is when I want to mention the security situation and its impact in the light of the cases that relate to violation of Article 3, complaints against ill treatment by law enforcement. And there are some individual measures in place, so we launch criminal proceedings based on the judgments of the ECHR, and we hold verification of these complaints and allegations discussed by the ECHR, identified by the ECHR when they looked at this case. And we have already cases whereby the investigation takes place at the local branches of the police and the SBI, the State Bureau of Investigations. And they cover areas with active combat, and that's why receipt of information can be delayed. Sometimes it's just not possible to get any information from those areas. In light of this, I want to mention that regardless of some objective reasons for not getting information because of full-scale aggression of Russia, nevertheless, the key emphasis in this work should not shift. We do have to address system-related problems mentioned in the ECHR judgments. And the addressing of such complex system-related problems, and it's been mentioned on multiple occasions today, will help receive better consequences for us, meaning changes in the legislation and compliance of that legislation with the convention and ECHR standards, and improvement of enforcement. In the future, it will help comply with human rights principles in each and every case, and that would mean less cases at the ECHR. That is the result that we all want. To finalize my presentation, I want to thank all of the participants for your efforts in terms of executing ECHR judgments, and we do have positive dynamics in this regard. And I call upon everybody to step up the efforts so that we could attain better results in the process of executing ECHR judgments. Thank you so much. Thank you for your attention.
Дякую. Дійсно,
Thank you. Well, it's true that the statistics of the decisions of the Cabinet of Ministers, those that have been closed down in terms of the oversight, shows that Ukraine is really having some progress in the enforcement of the judgments. Because of the armed aggression against Ukraine, a very important issue that is now discussed almost everywhere is the issue of the liability of the Russian Federation for the effects that Ukraine, of the aggression that Ukraine has felt and continues having. One experts are saying that the European Court is an effective institution to provide legal remedies. Others are suggesting that that should be another issue. I have the honor of inviting Pavlo Pushkar from the Department of the Execution of Judgments of the European Court to speak about the issue of liability for serious and grave violations of human rights guaranteed by the Convention. What can happen, what will happen, and what are the general vectors of development here? Thank you very much, Irina. I hope that you can hear me well. The connection is technical and not. Thank you for participation in this event. I want to thank the organizers. Pablo, we cannot hear you. And the picture freezes up. Perhaps you can turn off your camera and therefore the connection may get better. Pablo, can you hear us? Are you with us? No, the quality is very bad.
Так, чи можливості з точки зору звуку, то, можливо, тоді без відео буде набагато простіше.
Maybe it would be easier without a picture. Let's try.
На жаль, наші плани стосовно
Unfortunately, our plans as regards the meeting of the Parliament, Verkhovna Rada, in terms of the execution of the judgments of the European Court have been put off. And let's hope that when the time comes, we will come back to this. I would like to congratulate you with the recent adoption of the laws at the number 4323 and 4324, for which 301 and 288 MPs voted, dealing with the enforcement of the execution of the judgments of the European Court in Nemerzhitsky. And once again, this underlines this important thing that Ukraine is dedicated to Article 46 of the Convention, meaning the execution of the judgments of the European Court. And our cooperation with the government agent, although it is very intense, but we still hope that at some time the government agent would finally be appointed who will deal with representing the cases at the European Court, as well would deal with issues of the execution of judgments of the European Court of the Committee of Ministers. And once again, the same issues remain. The issues related to the systemic and structural problems, the issue of modification of the model of the execution of judgments of the European Court based on the law of 2006. Here, really, one can speak about an important example of the UK, but now we see all kinds of discussions taking place at the UK Parliament about the need to improve the model of the law, which is a model for the Ukrainian legislation, the model of 1998, that in fact is used without many changes since the time when the law was adopted. And we know, we've discussed it a lot, that thanks to the expert opinions made at the Council of Europe by 2017, some of those aspects can be reinforced. And these are the issues also related to the future. And so in the first part of my speech, this is what I wanted to say. Before I reach the issue of liability for such grave systemic violations of human rights. We call it gross human rights violations in Ukraine. Before I start answering the questions put by Irina, I would also like to say that as the situation is in July of 2022, the Committee of Ministers has really stopped its oversight about quite a large number of cases versus Ukraine, 110 leading judgments of the European Court of Human Rights, 12 of which were an enhanced overview of the Council of Europe, were closed down by the Committee of Ministers. 972 repeat cases were also closed down, 148 decisions on the friendly settlement, 22 of them with some additional conditions, and some judgments that have already been mentioned by Margarita today, and Lutsenko number 2. And here I would also like to note certain developments that were related to Stetsov versus Ukraine and Sosudovka Church versus Ukraine. Oversight in terms of implementation, our execution was also closed down. And another important piece of progress is the ratification by the Istanbul Convention in terms of prevention of domestic violence. That directly is not a part of the measures in Levchuk and others. However, it is quite possible that the ratification of the convention will be one of the issues to be considered by the Committee of Ministers of the Council of Europe, perhaps even in December of this year. In the conclusion of the short overview of the situation with the execution of judgments of the European Court, we can say that in July of 2022, the Committee of Ministers continues its oversight over 108 leading cases that are pending at the Committee of Ministers, of which 51 cases are in the enhanced oversight procedure and 55 cases are in the standard procedure of oversight, plus several cases would be classified, well, categorized, receive its category at the meeting in December. 586 repeat cases, of which 503 are the cases that have joined the enhanced oversight, and 80 cases that merged with the standard procedure, and several more cases would be categorized by the Committee of Ministers in March or probably in September of this year. As we see the aggressive war against Ukraine intensify, the Committee of Ministers has decided to put off the consideration of several cases that were to be considered in March and June of this year, in particular cases related to serious systemic and structural problems, Fedorshenko, Luzenko, Kongadzev, Kavertsin, Afanasyev, Ivanov, Burmich, Svetlana Naumenko, Volkov, Ikhvatov, and Logvinenko, Sukachov, and Nemerzhitsky. These are the cases that were planned to be considered in March of this year, probably in September of this year, which, as the preliminary agenda suggests, would be put off till the following dates related to the execution of judgments of the European Court. Quite a lot of issues have already been mentioned by Margarita, but some of them related to the liability in the future. And here we can mostly look at not so much at the issue of liability of Ukraine for the execution of judgments of the European Court, but rather look to see what role Ukraine can play in the mechanism of collective responsibility in terms of the execution of judgments of the European Court vis-à-vis the Russian Federation. Several words about this subject. The Russian Federation will not be a party to the European Convention of Human Rights as of the 16th of September 2022. However, the decisions made versus the Russian Federation are to be executed. They will remain valid in terms of the international law. So those judgments that have already been rendered and will be rendered will have to be enforced within the mechanism of the execution of judgments of the European Court. And here a question arises as to what the process may look like and what the consequences of the would-be judgments of the European Court can be, both intergovernmental judgments or decisions, and how the process of execution will look like. While a party, the respondent state, is absent. We could already see that during the latest meetings of the Committee of Ministers, both in March and in June, and we see the preparation of the committee of the session of the Committee of Ministers in September, the absence of the information to be provided by the Russian Federation, as well as possible failure to participate, the risk that they will not participate in the meetings of the Cabinet of Ministers in September of this year. Therefore, some more questions arise. What can be the model of rendering such decisions, and how it can affect the behavior of the Russian Federation, and how the status of execution of judgments versus Ukraine can affect the obligations versus the Russian Federation. In other words, how the standing situation in terms of the execution of judgments of the European Court can affect that mechanism of collective responsibility in terms of the execution of judgments. Another issue is the issue of coherence and the responsibility of the Russian Federation for the so-called violations, blatant violations or systemic violations of human rights. And here we're talking about gross human rights violations. Now, we can find facts or allegations of such violations and their intergovernmental applications. And most probably, these are the ones that we can call gross human rights violations or allegations in terms of MH17 case and related to the Crimea case, in which a decision has already been made about its admissibility. And here a number of issues emerge as to what the potential effect of such judgments can be if they are taken, and we already see certain problems that the Committee of Ministers is facing while overseeing the execution of intergovernmental cases on the judgments of Georgia versus Russian Federation #1 and Georgia versus Russian Federation #2. The judgments related to the states with the so-called intergovernmental elements. The coherence of the mechanism of international responsibility means not only responsibility for the European Convention of Human Rights, but responsibility on the basis of other standards or systems of international law. And this kind of responsibility should be synchronized with a mechanism of responsibility according to the European Convention of Human Rights and the mechanism of the execution of judgments of the European Court. In addition to the current mechanism of international responsibility, in particular the procedures at the International Criminal Court, the Ukraine is now proposing to fill in the gap within the system of international responsibility vis-a-vis the Russian Federation for a violation of international law and for gross violations of human rights, and by creating two additional institutions and processes. The first one is the process of establishing a non-ad hoc tribunal as regards the crime of aggression, and the other is establishment of a commission on damages that should provide a systemic solution for reparations and damages inflicted by the aggressive war against Ukraine. I'm sorry, we can no longer hear Mr. Pushkar. This is an issue that is widely discussed now and at high-level forum. It would be logical to establish such a tribunal where it is impossible to prosecute the crime of aggression. Sorry, there is no sound.
Пане Павле, ми чуємо. Підкажіть мені, будь ласка, Павло Пушкар відключився.
So we lost Pavlo, right? Pavlo Pushkar. Or he's gonna be back. Maybe his communication line is not working. Can you hear me now?
Да.
So I'm back online. Apologies for that. So then there is the second part, which is about compensation claims commission for Ukraine. And this commission will fill in the gaps in terms of accountability mechanisms. The task to establish such a commission has been mentioned in the presidential decree. So they created a working group, including the members of the Council of Europe, and they will talk about and discuss the accountability system. Both systems should be synchronized, and they should base their operations on the case law of the ECHR and also on the practice of implementation of the judgments. So this commission will build its operations on three important segments. They will create a register of complaints with regard to victims and damages, then the reparation fund to restore damages, and also enforcement or execution. So in this case, of course, they need a lot of hard work. There are so many legal nuances related to the case law of the ECHR and also the requirements of the international law. I mentioned that today. That is connected to the immunity of the state and the conventions of UN and Council of Europe with regard to confiscation of property, then the case law of the European Court of Justice. So there are so many segments which need to be addressed in due course, including the segment of evaluation of damage and the payments and everything. All these segments are complicated. And today we celebrate 25 years anniversary of the convention. And that means that it has become a part of collective accountability of Ukraine. And also that is an evidence that Ukraine is committed to implementing international law. And as I mentioned before, all these requirements will have to be synchronized with other sectoral requirements and should be based on the principles of international law. So those are the things I briefly wanted to mention. I hope that at a later occasion, I will be able to speak more about the ad hoc tribunal with regard to the crime of aggression in the future. So in October, hopefully September this year. And also I will be able to present information about the Commission at other conferences of the Council of Europe where we will have already a good solid concept of the mechanism and when we will work out all the legal nuances of accountability at the international level and also things that are connected to the violations of the international law at the national level, because we also have a principle of complementarity and subsidiarity in place from the standpoint of international criminal law and national law, because they will play a very important role. That's why Ukraine's commitment to the European Convention of Human Rights and respect to the rules of international law are very important in today's situation for Ukraine and for the Council of Europe. So now let me use the opportunity and thank you. I apologize for the technical difficulties. I hope I still was able to deliver the message quickly and succinctly. Thank you. Likewise, thank you. Well, generally speaking, it's just the beginning of the discussion with regard to effectiveness and efficiency of enforcement. I have to apologize before all of the participants. Everyone who wanted to reflect and ask questions, I absolutely apologize. I cannot give you this opportunity because we have to close this conference. And for this purpose, I'm giving floor to Andrei Kostin. Thank you, Irina. Thank you so much. Just give me a minute, please. Apologies for being offline a little bit. But I still was monitoring what you were discussing. I really wanted to make sure that this conference is a positive one, an optimistic one, even in the conditions of war, even in the conditions of the armed aggression, even in the conditions of issues, tragedies that we face in Ukraine every day. This high-level discussion which we had today is inspiring towards very serious work which we will have in the future. I sincerely, from the bottom of my heart and from the public of Ukraine, as an MP of Ukraine, not just as the chairperson of the line committee, I am an MP. First and foremost, I'd like to thank you, dear colleagues, dear experts from the Council of Europe, from the ECHR, from the Venice Commission, for this absolute, honest, and proactive role which you play and which you are prepared to play in the future so that every Ukrainian citizen would feel safe and protected. Our task, the task of the government, is to offer the tools which we have at hand according to the Constitution and the laws of Ukraine. When we adopt the laws, when we enforce those laws, we want to make sure that each and every person feel that his or her dignity, rights, and lawful interests are fully protected. And the best result for all of us would be the situation whereby, and I mentioned this some time ago when I was a lawyer, so I said that the best result for Ukraine will be a lack of complaints from Ukraine to the CHR, because all the rights and legal interests will be protected by the future legal system and the case law, which will reign in Ukraine, and which will be based on best standards from Europe, as mentioned today by Henatovsky. Thank you so much for this easy to understand formula whereby European standards are the standards of the Council of Europe. That's very important for us. Thank you so much. Thank you once again. And I want to assure you that the Ukrainian Parliament and the Line Committee, the Parliament responsible for policy making in this regard, we are ready, as our President says, 24/7 to cooperate, to make sure that this dream about the European future our citizens, Ukrainian public, will come true. Thank you.
Дякую і запрошую до заключних слів пана Крістоса Джакамопулоса.
Thank you, Christos Giacomopoulou. Over to you for final remarks.
Thank you so much. I would like first of all to thank Andrei Kostin for his last words and for the determination to consider this conference as optimist and positive, as he said. And I think that we are all agree with this. And actually, it was the case. We usually, when we have celebrations, anniversaries, we only look into to the past, and we take stock of what has happened, and we celebrate. And this conference was more than that, actually, because we looked very much into the future. And I think that after this conference, we can clearly say that the European Convention of Human Rights, the Court, other institutions of the Council of Europe, in particular the Venice Commission, are extremely important because they provide, on the basis of those European standards, they provide an extraordinary needs assessment, a kind of roadmap of measures needed to secure the well-being of the country, the well-being of the people, the sound functioning of democratic institutions, and also the approximation, as the European Union says, of legal systems. I would say perhaps the creation of a wide common legal system positively based on human rights as a common tradition of European states. And Ukraine is a very good example for this. It's not the only one, but it is a very good example, because from the constitutional reforms that have started more than 25 years ago, to the reforms of the judiciary, the functioning of the courts, the status of judges, the organization of the prosecutor's service, the reform of the prosecutorial service, the reform of the criminal code, also to the conditions of detention. All this is actually based on the European Convention of Human Rights and the case law of the European Court of Human Rights. All the reforms introduced over these 25 years have heavily relied on the European Convention of Human Rights. And this should continue. I can easily consent that it is not the easiest way. But I would like to stress that despite the aggression, despite the difficulties, despite the challenges that the Ukraine and the Ukrainian society face, the democratic choice of Ukraine and of its people shall prevail. And the temptation to follow other easier ways which could perhaps give some short-term efficient results, but which will be less inclusive, less transparent, and ultimately less sustainable, and unable to create the democratic stability that is needed, would not work. So I believe that because Ukraine is not a kind of pawn in the geopolitical arena, but a member of the European family, a member of the Council of Europe, and as such, it is shaping, together with the other member states, the fate of the continent. As a member state of the Council of Europe, this should continue to be so in the next 25 years and perhaps even more. So I would like to thank all of you, in particular, of course, Andrei Kostin, President Knyazyev, but also Judge Henatovsky, my good friend from the past, Hanna Sukhotska, with whom we have been working in Ukraine quite often, Jeremy McBride, but also Judge Larissa Rogach and Misoro Sokorenko, and of course all my colleagues, Pavlo, Irina, and Mitro, for their contribution to this conference, which, as Andrei Kostin said, it is actually an optimist conference and a positive one. Thank you very much.
Я дякую всім учасникам
Thank you,
нашого.
dear participants of the roundtable. Thank you, because I think it was a success, same as the Convention of Human Rights in Ukraine. This conference was very important for us to end up on the same page in times of aggression. And I'm talking about the project team, I'm talking about the projects which we have in the office, because we want to provide help to government. Thank you, everyone. Thank you so much. And a lot of thanks to the translators who, in spite of us delaying everyone, they stayed with us no matter what, and they made sure that we understand each other. Dennis, Vadim, thank you so much. Thank you for staying with us all this time. Thank you and goodbye.
До побачення.